returnable 3 weeks. Melody, it ought to have come up for motion. It doesn't come. Can it come on Friday, man?
Motion.
Motion published.
May it please your lordship. Let the matter be listed on 19th, my lord.
Which matter?
This is a contempt case, my lord. What happened in this case? Last occasion, 38/9/2024, it was listed and they took 2 weeks time to showing the compliance order. But till today, nothing happened. That is why I mentioned, my lord.
Friday.
Friday. Obliged.
Similar prayer, your lordship.
Huh?
Similar prayer, their content matter, your lordship.
Contempt matter.
Content matter, your
All
lordship.
right.
On Friday, not on Friday.
Right.
Here, my lord, I have also one confirm matter, and here one motion matter, my lord, will be listed on Friday.
Friday. Motion next week? Monday?
Very urgent, my lord.
What is the urgency?
Urgent is there. I have urgency, my lord. I have, my lord, challenged the one executive order, my lord. And on the basis of this executive order, my lord, the applications are being submitted by.
Compassionate appointment.
Yes, my lord.
That date is already gone.
My lord, that
So you are challenging.
challenge is
What
there, my
urgency?
lord. But yet,
Monday. Monday. There's no urgency like that.
So I am praying for listing of a motion on Friday.
What matter? What urgency?
That's it. This is with regard to suspension, that's it. Prolonged suspension.
Prolonged suspension. Let it come on Monday? Yes. Monday.
I will, for listing, my lords, on Friday, 2 fresh writ petitions, my lords. Suspension but not prolonged, my lords. The suspension is without jurisdiction. my lords.
Monday.
Monday.
May I please, Lordship? Lordship, I beg to mention the motion item, Lordship, on any date next week.
Tuesday.
Lordship, highly offensive.
My lord, the petitioner, my lord, derived from my lord, appearing physical test, my lord, he passed computer-based examination, my lord, the matter listed, my lord, in court number 6 twice, but remain left over, my lord, urgency is there.
In
my
this
lord.
court.
Physical
Leftover in
test.
this court.
Friday.
Leftover in this court.
No, court number 6.
Friday.
Court number 6 is not sitting, my lord, that is.
Already Friday.
Right.
May it please, my lords. Item 35, my lords. Consent of the other side, my lords. Consent of both the parties, in fact, my lords. We pray for an adjournment, my lords. Some talk of compromises going on, my lords.
Item 35.
35. My learned friend appears for the other side.
Concept is there, Lordship.
Item 35 in the submissions of both counsel, of counsels for both parties. Matter stands deferred to be listed after 6 weeks.
6 weeks to be.
It is submitted that parties are attempting to resolve the dispute outside court.
My lords. Deeply approved.
So, Lordship, I'd like to mention WPC 1778 of 2023 for withdrawal, Lordship, on Friday.
Friday only.
Obliged.
Wait, please, Lordship, I beg to mention item 44 on today's list. If taken consent of the other side, on behalf of the respondents, Lordship, 1 more week is required for the affidavit. Perhaps it may be taken up after vacation.
You are for the respondents?
Yes, Lordship.
I am for the petitioner, my lord. It is a pension matter, so date may be fixed,
It has to be after vacation.
my lord.
After vacations.
After a date may be fixed, please.
On the request made by Mr.
A. Atreya, Lord.
A. Atreya, learned counsel for respondent 2 and 3.
Yes, Lord.
Matter stands deferred to be listed on
For admission here,
24th October. Mr. A. Ahmed appears for the petitioner, does not object to the payment. 24th October.
Lordship, I beg to mention item number 43. The consent of the other side, Lordship, can it be after the vacation, Lordship?
43.
For the respondent, Lordship.
43, you have taken consent.
I've taken consent.
Mr. R.K.D. Chaudhary, Deputy Solicitor General, submits that this matter be listed after the ensuing vacations. He has submitted that consent of the counsel for the petitioner has also been obtained. Accordingly, list in the first week of November.
So, nice.
Wait, this place. I beg to mention item number 20, Lordship. Can you adjourn for 20, Lordship?
20,
20, Lordship.
20 or 21?
20, Lordship. 20.
20. Item 20 and the request made by the counsel for the petitioner stands as deferred. You want it adjourned to be listed after the vacation?
After vacation, Lordship.
Why?
Lordship. I'll pick after vacation, Lordship.
Motion matter, why you are adjourning after vacation?
Then next week, Lordship.
Next week. All right, next week, Tuesday.
May I please? Lordship, I beg to mention for listing Lordship, pending cases only due to appeal has been preferred by the government Lordship, appeal. And yesterday it was dismissed Lordship. So Lordship.
Appeal was dismissed.
Yes, Lordship.
It will be after vacations.
Lordship, before vacation Lordship.
Before vacation, next week.
Pensionary benefit Lordship.
Next week has been declared to be a motion day. This is for admission, I believe.
Yes.
So let it be immediately after vacation.
Your Lordship.
On 17th October.
Your Lordship.
17th October, you correct the date.
Your Lordship.
May I please, Lord, I beg to mention for listing one contempt, my lord,
Hmm.
on Monday, if possible.
Fresh matter.
No, my lord, pending.
Pending matter, let it be after vacation.
Listed on 2/6 on last.
Let it be after vacation.
Lordship.
17th October.
May I please, Lordship? I beg to mention for listing Lordship of arbitration petition for motion limits. Mention list for listing Lordship,
Listing what matter? Fresh matter, pending matter
pending matter Lordship, for motion Lordship.
motion.
Yes, Lord.
Motion.
No, for motion, yes, Lord.
Matter be listed for motion or
Yes.
admission.
For motion Lordship.
For motion. When was it
Fresh
last?
matter, Lordship.
When was it last listed?
Last listed on Lordship, it was on 10 September.
10 September,
Yes.
right? Verify, court must verify if it is for motion, let it be listed. Next week, give a date. Yes,
Please, Lordship, I beg to mention item number 22 for withdrawal, Lordship. There is an error, Lordship, we have to rectify it.
22.
Yes, Lordship.
22 on the submissions made by Mr.
And Ali,
N. Ali.
Lordship, kindly grant us
That
liberty.
the some inadvertent error has crept in while filing the petition, seeks to withdraw the matter with liberty. Prayer made is not objected to by the counsel for the respondents. Accordingly, the petition dismissed on withdrawal with liberty.
Obliged, Lordship.
Make clear.
Yes.
Lordship, in item number 7, Lordship, while stitching, Lordship, page 10 is inadvertently left out, Lordship. May I be permitted to stitch it? All the corresponding annexures are there in the, but only the page 10 while stitching, Lordship.
So
Lordship, if Lordship permits, Lordship,
what do you want?
I can stitch it back. Lordship.
You can't stitch it back now. You bring it by way of some you bring it by way of an affidavit or something.
Affidavit.
Or affidavit or whatever. Affidavit will do.
Yeah,
Bring it by way of an affidavit.
yes, Lordship. Lordship, then take this matter on Friday, Lordship.
Friday, Monday.
Monday. Deep.
Item 7 on Monday.
Deep.
May I please, Your Lordship? Lordship, I beg to mention one unlisted review petition, Your Lordship, for listing tomorrow, Your Lordship.
Unlisted review.
Yes, Your Lordship. This review petitioner is the Arunachal Public Service Commission, Your Lordship. So we have filed a review petition before Itanagar bench on 8th of this month, but this has not been listed. So I'm praying for listing it tomorrow, Your Lordship, because there is an urgency, Your Lordship. The examination has been rescheduled for 28 and 29th of this month. So
You have to apply before the registry.
that we have done, Your Lordship. Forwarding was sent from.
All that subject to permission being granted to the registry. To the registry.
Lordship.
If the registry can,
Yes, Your Lordship. Forwarding was already sent from Itanagar register to.
they'll have to be placed before the Honorable Chief Justice
Lordship.
for getting a permission. The registry will do the needful.
There is some urgency because of
No,
that,
but you-
Lordship.
You approach
Yes,
the
Your Lord.
registrar judicial,
Lordship,
and if the permission is granted, then we'll list it.
Lordship, for tomorrow. Obliged.
May I pray for listing of an admission matter on 22nd, Your Honor?
No, and the next week is all motion day.
Lordship, otherwise, the fact is that respondents have not yet filed their affidavit, Lordship, just for that reason. Any day, Lordship, next week.
No, let it be after, immediately after vacation, you have it 15th October. 15th October. Yes. This appears to be bench 2 matter, is it? Civil bench 2. Civil bench 2. This is a civil bench 2 matter. Registry to list this matter before the appropriate bench. as it pertains to civil bench Roman 2.
My lord, is a transfer matter, petition is a basic constable, but after filing of the writ petition, my lord, so far the instruction, already the representation has been considered by the department.
Already?
Representation filed by the petition has been considered by the department, so my lord, I have been instructed to do this petition. my lord.
Mr.
MA.
Leonard. Counsel for the petitioner. MA Islam, counsel for the petitioner, submits on instructions that writ petition has become infructuous. Accordingly, petitioner does not wish to press the same. Therefore, the writ petition stands dismissed as not pressed. Mr. P.S. Bhattacharya, Leonard CGC, appears for the respondent. Dismissed.
All right.
Yes.
Item 3, your lordship, if you notice in the matter, your lordship. This matter was filed by 6 of the persons who were part of the union, your lordship. Their service has not been regularized, your lordship. Some people have died in between and your lordship. So here, the issue is they have to be regularized also because what happened, your lordship, the award was passed in 99. Award they took for directing for regulation of the service. Then it came to single judge, and single judge affirmed the award. Then it came for division bench. Division set aside the whole thing and remanded it back on the ground that steel authority judgment was not followed. Whereas steel authority judgment came in 2001 and the award was passed in 99. Thereafter, the petitioner went to the apex court. Apex has set aside the judgment and direct for regulation. Thereafter, what happened, your lordship? The learned senior counsel who appeared, he said some issues had not been decided, so it was remanded back to High Court. The division bench again decided the matter, dismissed the writ appeal of the respondent. Thereafter, they went to apex court. That was also dismissed. Then 2019, they started regulating as a fresh appointment, whereas the award was something else. So other matters concerning that, they have been, the present matter, these people have died in, some expired and some has retired, your lordship. During the pendency, because 99 award, for 20 years they got hanged, then in the meantime, some of them died in service, your lordship, it happened. So it is for regulation and distinct for these people, your lordship. It's 6 persons.
But we have instructions to appear, but firstly, we don't have a copy as yet. But what I've gone through the records, my lord. I don't know how this petition is even maintainable. Item 3. Because on the same subject matter, the same petitioner has filed item 4. Exactly identical cause of action. So this
has been filed on behalf of 49 employees, not all of them.
Same organization, how can they go on repeatedly filing?
It's not that
petition after
these people have the subject matter is slightly different also. They have been not been regularized. These people are regularized. So the issue is slightly different, your lordship.
You bring it, you raise your objection.
Yes, sir.
Your lordship,
We'll make the maintainability open.
yes, that observation may be made and copies may be served.
Yeah, I'll give you a copy now.
Right. Will you issue notice today?
Yes,
What
sir.
else?
Otherwise,
Mr. P. Chaudhary, learned counsel for the petitioner. The petitioner before this court is, this is by the Mazdoor Sangha.
yes, sir. Yeah.
Mazdoor Sangha has filed this writ petition against the respondents seeking regularization of some of its members in terms of the award dated 3/12/2000
Yes, sir. Yes, sir.
passed by the Industrial Tribunal Guwahati in reference number 21 within bracket C of 1999. Where Mr. Rai Chaudhary, senior counsel, representing the respondents on instruction submits that this writ petition is not maintainable because on similar issues, the WPC number 5245.
5245.
5245 of 2024 has also already been filed.
Even otherwise, on several other grounds also, it is not maintained.
We'll see that.
By the petitioner, where the court has already issued notice. Therefore, there is no cause to file a subsequent writ petition on the same issues. Well, be it as it may, considering the submissions made and on the issues raised here, let notice be issued. Returnable 4 weeks. Mr. B. Chaudhary. Assisting Mr. I. Chaudhary appears for the respondent, sole respondent, and accepts notice. Therefore, notice is waived. Extra copies we furnished within a period of 2 working days.
I'll give it today.
2 working days. Mr. I. Chaudhary, Senior Counsel for the respondent, has raised the objection about regarding the maintainability of the writ petition. Stopped. The question of maintainability will be decided at the time of admission. The respondents may file their objections, affidavits, if any, if so advised. In the meantime, list. So these 4 and 5, these are connected matters here. Right, list all these matters in the month of November.
Yes, Your Lord.
November. You want a fixed date?
I would like to take a look. Can I have it, Your Lordship, subject to my letter convenient? 3rd of November?
3rd of November.
Yes, Your Lord.
Can it be 10th, Madam?
10th of November.
No problem.
All right, 10th November.
No problem. Deeply obliged.
All right.
Lordship, instruction received, Lordship, here in this case, Lordship. Lordship, the projection of the petitioner case is that whether the order passed by the Deputy Commissioner, Lordship, on 8/9/2025 is punitive in nature, Lordship. Here, in point 1,
No, what is your grievance here?
My grievance is that, Madam, the petition is pending before this honorable court. The Lordship will find the order at Annexure 6, page 26, Madam. But this case was filed for promotion, Madam, from the post of senior assistant to head assistant, Madam. Madam, this honorable court was used to issue notice on 1st of this month, Madam. With an observation, Lordship will come to a para 8. This observed that the pendency of registration shall not be a bar for the responding authorities to undertake the promotional exercise, fill up the post of head assistant, which is stated to have been vacant in accordance with law. But after passing this order, I have served this order to the authority. Authorities, Madam, as a punitive action, Madam, they have transferred me.
Which order is there?
My order is, Madam, page 29, Madam. And I am employee of the health department, Madam.
It
And
is if you are transferred out, if you are transferred from your present place of posting, then you can't be promoted to the next place.
Yes, Madam. That's why as a punitive action, Madam, the district collector has issued the order, Madam. Under what authority, Madam?
District Commissioner.
Yes,
Who can issue the order?
The health department, Madam.
No, Lord.
Health Department.
Madam, I am the
But
employee of the health
you're
department.
posted in the office of the District Commissioner.
Yes, Madam. Well, on the last occasion, Madam, my learned friend has produced notification of, Madam, the 9th of September. I requested him, Madam, on that day, Madam, to submit a copy, but he have not submitted, Madam. After I have managed this order.
No,
I have gone through this order, Madam. As per this order, Madam, Lordship will find last 3rd line, Madam. From the above, Madam, to all other powers of appointing authority is pleased to authorize, empower the Deputy Commissioner of the district to transfer grade 3, grade 4 staff of all categories, including junior engineer and medical staff, such as nurse, laboratory assistant, etc., from one place to another within the same district and same department, Madam. This department was not mentioned by the email on that day, Madam. It has to be in the same department, Madam.
No, you are agreed by or impugned order at page 29.
29, Madam.
So you are at serial number 1.
I'm serial number 1, Madam.
So you are Senior Assistant Joint Director, Health Services.
Health Service, Madam.
And you are posted under the office of the District Commissioner, Biswanath.
No.
You are transferred to which place?
To the office of the District Commissioner, Madam. DC Biswanath Sarayani.
Joint Director Office to District Administrative Floor, District Commissioner Office.
So he was not working in the DC office.
No,
No, Lordship, he was working in the Joint Director Office, Lordship. And he was the Health Department, Lordship. He was transferred to the District Commissioner Office, Lordship. District Commissioner Office.
Now, same district, same department.
yes, my lord, same department.
What is the department here now?
He originally he is in the Joint Director Office, Lordship. Health Department, Lordship. Now he transferred to the District Administration, the Office of the District Commissioner, Lordship.
How can it be done? In
Lord-
terms of your own notification? Same department? Same district, same department.
No, Lordship, here, Lordship, so far in my instruction, kindly see my instruction, Lordship. Point 1, Lordship. I submitted,
Yes.
Lordship. That the order by number so and so was passed on so and so by the undersigned to transfer Sri so and so senior assistant from the office of the Joint Director of Health Services Biswanath to the District Commissioner's office Biswanath in the administrative branch for the interest of the public service and smooth functioning of the office works. The said order was passed on the basis of the
And-
notification of the government wide so and so. It means this notification, Lordship, in order to rationalize the workforce within the district and based on the requirement of the expedite the implementation of the various schemes or works. It is also mentioned here that he will draw his payment and allowances.
Right, you bring
from
it
his-
on record, you file whatever you want to file. File your objections
Lordship.
or affidavit. Heard learned counsel for parties issue notice. Notice issued, no.
No, my lord, not issued.
Returnable 4 weeks. Mr. J.K. Goswami, additional senior government advocate. That represents all the respondents.
No, no, no.
No, I am on
Respondent number
only,
two.
Lordship, 2.
Respondent number 2.
2, Lordship.
One open.
And Mr. J. Hendick for respondent 1. MS so-and-so appears for respondent 3, 4, and 5. As the respondents are represented, notices are waived, extra copies be furnished within a period of 1 week from today. Whereas the petitioner is agreed by the order dated 8th of September 2025, whereby he was transferred from his place of posting, namely the office of the Joint Director Health Service, Biswanath District, to the office of the District Commissioner, Biswanath, in the administration branch. So, counsel for the petitioner submits that this transfer interdepartmental transfer is not authorized. Interdepartmental transfer is contrary to the service rules governing the services of the petitioner. Petitioner is an employee of the health department, and therefore his services, therefore his controlling authority are the officers of the health department and not the district commissioner, Biswanath. But he therefore submits that the impugned order is contrary to besides being contrary to service rules, is beyond the powers conferred on the Deputy Commissioner or District Commissioner Biswanath. Mr. J.K. Goswami, additional senior government advocate, on the other hand, on instructions, submits that this transfer was done in the interest of administrative exigencies. He has referred to the notification dated 9th of September 2021, whereby it is submitted that grade 3 and grade 4 staff of all categories are permitted to be transferred by the Deputy Commissioner on the powers conferred from one place to another within the same district and same department in consultation with the district head. Para. Having noted the notification dated 9th of September 2021, it is seen that the deputy commissioners / district commissioners of all districts, excluding 6 scheduled districts, have been empowered to transfer grade 3 and grade 4 staff from one place to another, but within the same district and same department, and in consultation with the district head of the concerned line department of the district. In the facts of the present case, it is seen that the petitioner was an employee of the health department. He was he ever working under the DC?
No, my lord.
Earlier?
No, my lord. No.
Nothing is placed before the court.
Lordship, Lordship, instruction, point number 2, Lordship, kindly see. The administrative branch, office of the district commissioner Biswanas is important branch where the issuance of all certificate, verification, inquiry, fact certificate, different works of the health acceptor are urgently done within the stipulated time under ARTPS Act, Lordship. Since there is no efficient senior assistant in the administrative branch to look after specifically above mentioned matter, experts accepts accept a petitioner, Lordship. Here some health work is required, the health department's works.
No, but whether the DC, how can the DC transfer an officer of this?
Yes, Lordship, that interpretation is required. The personnel department is necessary here in this case, Lordship, because this notification was issued by the personnel department.
You get your interpretation from personnel department if you want. You are producing this notice.
No, Lordship, I am in my
reading, a plain reading of this says it is from one place to another within the same district and same department.
But
are you saying health department and deputy commissioner revenue department is the same?
Lordship, point 2, it is categorically clear, Lordship. Some health is department's certificate.
Mr. Council, please address the matters as a council.
Lordship,
the instructions which you have received are from your client. You have to interpret and address the court on the basis of these instructions. We can see what is written there. We are asking you in terms of this notification, 9th of September. It is apparent that same districts, same department.
Lordship, the language is that, Lordship, but
Then, even otherwise, from the health department, can the director health service transfer anybody from the DC's office? Mainly because some health work is required.
Deputy commissioner transferred.
See the reverse.
No.
Tomorrow, supposing there is a personal department notification which says we confer powers on the director health service to transfer grade 3, grade 4 from any other department. We are not, if this is not being challenged, it is a different issue. And then there has to be a consultation with the district head. In your points, it is not mentioned that the consultation is there. In fact, the DC has gone to the extent of saying that his promotion will not be hampered, etc. How does he know? How is he concerned with the promotion of this employee?
Because Lordship, his SCR graduation list and etc.
How is he concerned with the promotion? He is not an employee under the DC district commissioner's office. How is he concerned whether he is to be promoted, not to be promoted?
Lordship,
It's for the director health service.
Lordship, the deputy commissioner is the coordinator of all departments.
We agree.
Yes, Lordship. And he's the
But
head.
then what is the point in having service rules? It defines your appointing authority, it defines your disciplinary authority. Tomorrow, if you have to terminate this man, can the DC issue an order of termination? DC can certainly initiate departmental proceedings.
Yes, Lordship. Then Lordship, kindly issue the notice, Lordship.
This is
I
what
will
we are doing.
apprise.
This
I will
is
apprise.
exactly what we are
Yes,
doing.
Lordship. I will apprise.
Coming to the question of the prayer for interim order, it is seen from the instructions placed before the court that it is seen from the instructions that the petitioner has been transferred on exigencies of service as some health works are pending in the office of the Deputy Commissioner. It is also seen that the petitioner's claim for promotion to the next higher post of head assistant under the health department will not be hampered as his ACRs and gradation list, etc., will be submitted to his parent office, even if the petitioner is posted in the under the office of the Deputy Commissioner. So, considering the submissions, it is seen that the notification empowers the Deputy Commissioner to transfer grade 3, grade 4 staff of all categories from one place to another within the same district and the same department in consultation with the district head. So, a bare perusal of the impugned order dated so and so. From a bare perusal, it is seen that the petitioner has been transferred from the Department of Health Services to the District Commission Administration branch of the District Commissioner Biswanath. So, it is apparent that petitioner has been transferred from one department to another. This, on the face of it, appears to be contrary to the instructions, contrary to the notification dated 9th of September 2021. That apart, from the instruction, it is not clear whether the consultation with the district head of the concerned line department of the district was also obtained at the time the impugned order, before the impugned order dated 8th of September was issued. Under such circumstances, till the next returnable date, this court is of the view that the impugned order dated so and so. You have not joined.
No, madam.
Have you joined or not?
No. The order has been stayed, madam, as per the earlier order.
Oh, it's stayed.
First order.
Status quo.
Therefore, in the impugned order dated so and so passed in the earlier by the court earlier on 11/9/2025 shall remain stayed until further orders. Respondents may complete their instructions and file necessary affidavit.
B. Chaudhary is appearing in this. My lord, Mr. B. Chaudhary is appearing in this matter.
So, this is what?
Motion,
No, transfer.
no,
Then
disciplinary proceeding, I am a retired government servant. They have initiated a proceeding under the discipline and appeal rules. Your lordship is aware, once a person retires, the master servant relationship gets severed. So only option is to resort to Rule 21 of the pension rules. If your lordship will kindly come to the impugned order, page 67. I'm sorry, page 64.
62.
64 one.
64.
64, they have appointed the inquiry officer and even the show cause. Page 40.
When did you superannuate?
Long back, 29/2/24. So this is expressly without jurisdiction.
Get your instructions.
My lord, we'll have our instruction.
When? Monday.
By Monday.
Monday, next entire week I am away. Let it be immediately on reopening.
Right, heard learned county parties. Then we are issuing notice.
Yes.
The petitioner before this court is aggrieved by the impugned order dated 18th August 2025.
And also 30th August 24.
Where is that?
That is at page 40. That is the original show cause notice. And now 18/8 they have appointed and after a long 1 year, they have appointed the inquiry officer.
When did you superannuate?
29/2/24.
As well as the order dated 30th August 2024. Stop by the order dated 30th August 24. show cause notice and charge sheet was issued to the petitioner. And by order dated 18th August, the inquiry officer has been appointed. So it is the submission of the learned senior counsel that petitioner having superannuated as far back as February 2024. There was no occasion for the respondent authorities to proceed for departmental inquiry under the Assam Discipline and Service.
Discipline and appeal
Assam Services Discipline and Appeal Rule 1964. Stop. In fact, upon superannuation, the master-servant relationship between the petitioner and his employers had severed. The only option available is to take recourse to the appropriate provisions under the Assam Services Pension Rules. Therefore, he submits that the entire proceedings is without jurisdiction. Therefore, the same should be interfered with and set aside. Para, Mr. Chaudhary, on the other side, tell us.
Lordship.
You have drawn up proceedings against a retired person?
That's from the pleadings here in Lordship, it appears that.
So we are issuing notice.
Yes, sir.
Mr. B. Chaudhary, Learned Standing Counsel Finance, submits you up to obtain instructions in the matter. Accordingly, at this stage, let notice be issued, returnable on, tell us when you want it, 24th of October?
Yes.
Returnable on 24th of October.
Can it be 29th instead?
We just thought we'll ask you your dates before we give our dates. 29th of October. Meanwhile, the respondents being represented by Mr. Chaudhary, all the respondents, all the way, the extra copies we furnish, may complete his instructions and file necessary affidavit. Till the next date fixed, the proceedings initiated under the against the petitioner by the notice dated
3824.
3008-2024 and all consequential action shall remain stayed till the next date fixed.
Oblige.
Item 9.
May it please your lordship. My lord, the petitioners before your lordship, my lord, they are medical social worker and my lord psychiatric social worker in medical colleges of Assam, my lord, which are my lord practically teaching job. Now there was a decision of the government way back in my lord 2006, redesignating this post as my lord lecturers. Now it will be assistant professor. That has not been carried out. If your lordship kindly comes to page 39.
No, for today, we can issue notice.
Yes,
that's all.
Yes.
Heard Mr. M.K. Chaudhary, Learned Senior Counsel, assisted by Mr.
M. Sharma.
M. Sharma. Counsels for the petitioner, Mr. A. Chalia. For
124, Lordship.
124. And MS
Sharma.
A. Sharma for 5. And who's for 6? Anyone for 6? Is there any standing counsel?
Oh, yes, my lord, we have survey copy. Mr. Somo, my lord, A. Somo.
Mr. A. Chomoa, appearing for respondent number 6. Since the respondents are represented, notices are waived, extra copies we furnish. Respondents may complete their instructions and file their affidavit, if so advised, by the next returnable date. There is no interim prayer otherwise.
My lord, I have got a prayer, my lord. That your lordship may kindly make an observation that pendency
Pendency of the writ petition shall not be a bar to ameliorate the grievances raised by the petitioners, by the respondents.
My lord.
Item 10.
Make it lordship, my lord.
Yes.
But in the instant matter, my lord, the imprint creditation list published, my lord, with the remark, my lord, my promotion spec has been kept under the seal cover, which is that since no charge sheet or charge memo has been filed against me, my lord. And it's the absolutely, my lord, there is a guideline of the Honorable Apex Court as well as our High Court, my lord, that cannot keep my promotion not seal covered, my lord.
What is the status of the promotions otherwise?
Madam, if management may.
Lordship, the promotion is kept under seal cover. He
Yes.
says that there was also a simultaneous DP going on. So he says he has been acquitted from those charges. But we don't know the stage of the
DP
criminal
has already been
proceeding.
dropped, my lord. Admittedly, my lord, can you have a look at the lordship is passed order on page 47, by the first earlier occasion, my lord. I approached this honorable court, my lord. I made an application for consider my promotion, my lord, after dropping my charges, my lord, at page 47. And this honorable court had directed me, lord, to consider as per law my representation dated 30/9/2024.
That was considered.
Yes, my lord, instead this creditation is prepared and that
Is there
negative remarks made against me, my lord.
Negative remark.
Yes, absolutely, my lord. They cannot keep my permission in the seal covered, my lord. This honorable court, as the apex court held that, my lord, until and unless the charge sheet or charge memo has been filed, they can restart that.
Is there any criminal proceeding pending?
My lord, there is no charge sheet has been filed either. No charge memo has been filed against me till now, my lord. But it is clearly stated by this honorable apex court, my lord, in the case of, my lord, that is,
No, that will
yes,
have to decide.
Janki Raman, my lord.
Let them get their instructions. If you want, we can issue notice.
My lord, let them take instruction to, so that my prayer may be considered at the motion stage, my lord. Let them take instruction, my lord.
We don't know. Instructions.
Regarding, my lord, what is the stages of vigilance, my lord? Since admittedly, my lord,
All
no
these
charge
things will have to be brought on record.
my lord.
Everything can be on oral submissions. Whatever they want to say, we want them this on record
No, it
to
is charge sheet
come to
memo.
a finding that whether the decision to keep it under seal cover was justified or not. Your case is that on the day it was put under seal cover, no charge sheet.
Yes, my lord, admittedly, my lord,
That
no
is your
charge sheet.
case.
Yes, yes.
Now this has to be on record.
Yes, my learned friend is brought this in function before this court, my lord.
If you expect them to file an affidavit by Monday,
No, I'm not, my lord. I'm not, my lord. Let them, sometime may be given.
so
Yes,
we'll
my lord.
issue notice here.
Notice will come again order. So at the Mustan, if they bring instruction, my lord,
When? Within 1 week.
my lord. It was before last date of
Be
application.
realistic in your prayers. Therefore, we said we'll issue notice, let it come up in October. They can file, they file. If they don't file, we proceed.
Yes, lord.
Heard learned counsel for the parties. Issue notice, returnable 4 weeks. MS
M. Kalita, your lordship.
M. Kolita, ABS 4.
The Foreign
All.
Department.
For all.
Not all, your lordship. For 1, 2,
1, 2, 3, and
2, your lordship.
1, 2.
5
1 and
BTC.
2.
4 and 5.
MS A. Bothakur for 3, 4, and 5. Petitioner is agreed that his case has been kept under seal cover by the Departmental Promotion Committee while considering cases of the petitioner and other similarly situated persons for promotion to which post?
Deputy Ranger.
For the next higher post of Deputy Ranger. It is the submission of the petitioner that on the day when this case was kept under seal cover, no charge sheet has been filed.
Yes.
Therefore, the same is violative of the principles laid down by the apex court in J.V. Janaki Raman.
Yes.
Reported in so and so, and the other judgments issued by this court. Considering the submissions, let notice issue returnable on 17th,
my lord,
October.
My lord.
By the respondents may complete their instructions and file necessary affidavit. Please serve extra copies.
Yes, my lord.
Within the course of this.
Obliged, my lord.
11.
Yes.
Yes, your lordship. Lordship, this matter pertains.
Interview date is gone.
Interview date is gone, lordship. However,
What is left now?
lordship, in another writ petition, lordship, filed by another rejected candidate, leave was granted to the APSC to hold the interview in the event the petitioner could not be interviewed on the date as per schedule, lordship. So at this stage, my interim prayer is that similar relief may be granted in my case, lordship.
Which order?
Annexure, lordship, 2021, lordship.
Page number.
Page number, lordship, 86.
But this order was passed on 9/9
Lordship. But
and the dates of interview were 9, 10, 11.
yes, Lordship.
Today that dates are already gone.
Is correct, Lordship. However, my case is that I have the requisite qualification, Lordship.
Whatever it may be,
Lordship.
the molding of relief that you got from the court
Lordship.
or that the other candidate got was because it was on 9/9.
I filed my case on 10th, Lordship.
Whatever, the order was passed on 9.
Lordship.
What date is today?
It is 15th, Lordship. However, Lordship, the thing is that the selection process was entirely on the basis of
We are
interview.
not dismissing your petition.
Lordship.
We are saying we'll examine this matter. If required, we'll direct them to hold a fresh interview or if your rejection has been found to be invalid, we'll interfere. But to give an interim relief for them to hold fix another date
Lordship.
would not be proper because the dates are already gone.
That is
If you
correct,
had filed on 9th, why were you waiting for sitting on a fence for that long?
Lordship, actually, I filed an RTI application, Lordship. But the PSC did not provide any specific information regarding why my application was rejected, Lordship. That is why the long delay, Lordship.
When you are at the starting line, you have to decide whether to run or wait.
Lordship. However,
If you
otherwise,
wait-
Lordship, in the interim, Lordship, because the whole process is on the basis of interview. And if I am allowed, Lordship,
Interviews, dates have been fixed.
Lordship.
Is there any other interview?
No, my lord. Already 3 days are above her, my lord.
3 days are
We
over.
can have more so, my lord, that earlier petition and this petition are different footing, my lord. Earlier
Whatever it may be, earlier writ petition, the order was passed on 9/9.
Lordship.
So therefore, 9/9, 10/9, 11/9, 2 days were available.
Lordship, can I bring Lordship's attention to page number 90, paragraph 14, Lordship.
Yes.
Since the date of interview, YOC for the post of Junior Legislative Council and Undersecretary to the Government of Assam Legislative Department is scheduled today, that is 9/9/25, from 9 AM onwards. It is observed that if
When is this candidate's interview held?
9, 10 and 11.
No, this particular writ petitioner at
he-
page number 86.
9.
Huh?
9, same day,
Same day.
my lord.
Lordship, the rest of the part onwards, it is observed that if for any reason the
Any reason,
respondent
yes.
APSC authorities are not in a position to hold the interview YOC for the petitioner for the said post today, the respondent APSC authorities are at liberty to hold the interview YOC for the petitioners at any other convenient date to the respondent APSC authorities. Lordship. So they were given liberty to hold the interview in the event they were unable to interview on that particular day. So my submission is that if such similar prayer may be granted, then only I will be able to get the relief, Lordship.
What is your rejection ground for
The
rejection?
ground for rejection is I have less experience, Lordship. The other cases were on the ground that they did not provide COP, the certificate of practice. However, Lordship, at the time of filing my application, I had provided documents in relation to my experience, which are at Annexure 18, Lordship. Page number 74. Which are 3 copies of certified copies of Wakalatnama and 1 certificate from an advocate under whom I was practicing, Lordship.
But you see, you have waited from 9th.
Lordship.
Why?
Lordship, because of the RTI application, Lordship.
Who's responsible for that?
The petitioner, Lordship, that I understand, Lordship.
If you were come on 9th, if you were come on 10th, we could have passed some order.
I prayed for an urgent listing, but the same was rejected, Lordship.
That's a different issue. But
however, prima facie, Lordship, I am eligible, Lordship.
you may be eligible, but we'll have to decide it. We'll have to give them an opportunity to rebut to your submissions, contentions. Only then we can decide whether your ground is correct, incorrect, whether you are entitled to any benefit. But interim relief today, after the dates are over, directing them to fix another date on what ground? On what basis are you trying to convince the court?
Only on the basis of that paragraph 14, Lordship.
Then paragraph 14 is passed on the text of some other judgment. So we'll issue notice if you want.
Lordship.
Heard counsel for parties issue notice written above 4 weeks. Mr. P.J. Monto, assisted by Ms. P. Sharma, represents all.
110.
Yes,
1, 2, 3, 4.
Yes,
Since MSP Sharma accepts notice on behalf of all the respondents, notices are waived, extra copies be furnished within a period of 1 week from today. The petitioner had applied for the post of, you had applied for three
posts,
posts?
Lordship.
For 3 posts, applied for all the posts advertised by the APSC by the advertisement number 11/24 published on 1/6/2024. The posts to which the petitioner applied for in terms of the application are 1, 2, 3. Number 1, Junior Legislative Council and Under Secretary to the Government of Assam, Legislative Department, Assam. You find out from page 87, 1, 2, 3 Roman. The petitioner submitted his application by filing online. Some petitioner responded to the submitted his candidature through online applications. On 1/9/2025, notification was published giving the dates for interview viva voce for the 3 posts on 9/9/25, 10/9/25, 11/9/25 respectively. A rejection list was also published by the APSC along with an acceptance list for the candidates for the said 3 posts. The petitioner's name was reflected in the rejection list. Where is the rejection list?
Rejection list is at page annexure 11, 12, 13. There are 3 rejection lists.
Page.
49, 58, and 64.
In respect of all the 3 posts, the rejection list, the name of the petitioner appeared in the rejection list published. Showing him to reflecting that he was rejected on the ground of less experience. Stop. Counsel for the petitioner submits that this ground for rejection is totally uncalled for, and he has all necessary documents in support of his contentions that he is eligible for being considered for the interview viva voce, which was fixed by the APSC. Stop. Counsel for the petitioner submits that a similarly situated candidate had approached his court by way of WPC 5334 of 2025 and by order dated 9/9/2025. The coordinate bench permitted directed the APSC to permit the petitioner to appear in the interview, and if it was not possible to interview the petitioner on the dates published, then some appropriate date be fixed for interviewing the petitioner therein. So, counsel for the petitioner submits that he being similarly situated, he prays for a similar order. Better. Mr. Monto, on the other end, strongly objects to the prayer made. He submits that the interview dates were published and shown published as 9/9, 10/9, and 11/9. And candidates have been interviewed, and there is no further date for interviewing any other similar situated candidates. Stop. He further submits that the writ petitioner in WPC 5334 of 2025, namely Kitu Smita Borman, was also interviewed on 9/10. 9/9.
9, 10, 11. On they are also applied for the 3 posts.
And 9, 10, and 11 was interviewed on 9, 10, and 11. Stop. Under such circumstances, it is not possible to accede to the under such circumstances, since the dates of interviews are already over, the prayer of the petitioner cannot be accepted. Better. Considering the submissions made, let notice issue returnable after 4 weeks. The respondents may complete their interview instructions and file necessary affidavit also in the meantime. Issue notice on the interim prayer. We are issuing a notice on an interim prayer. See, list again on 17th October.
Develop.
But petitioner was provisionally appointed as a my lord, central notary public. Now that your lordship will find page 25, my lord.
Yes.
And 25, my lord. And page 28, my lord. My name is that.
We'll issue notice today.
The only thing is, my lord, here the issue is very simple. While uploading online, my lord, I have given my date of birth as per my documents, 28th of February 1967. But
Wrongly recorded.
they have in the system they have recorded is 1/1/2002. So
Where is your representation?
well, I made representation, my lord, date annexure 12 and 13, page 47 and 49. Sent a mail through mail. Page 47 and 49, my lord. Now, only thing, my lord, they take instruction on these, my lord.
Get your instructions. Page number 47 and 49 regarding correction of the date of birth.
Yes.
We'll have it on Tuesday or Monday. Heard learned counsel for parties. Petitioner is agreed by
On 25.
on
On my 25th of September.
might as well do it on 26th. Why don't you only have to get the instructions whether his date of birth has been corrected or not? We wanted to give it on Friday. Monday. Petitioner is agreed that pursuant to his appointment.
Well, provisional appointment. Provisional appointment.
Provisional appointment as notary public.
Well, central notary public.
Central notary public. His date of birth was wrongly recorded in the web portal. His date of birth is shown to be 1/1/2002 instead of 28/2/1967. Stop. He has submitted representations dated 4/6/25 and both by email as well as through post. However, the correction has not yet been made. Therefore, he is before this court. Mr. S.K. Medi, learned CGC, will obtain instructions in this regard. Let the matter be listed again on 22nd. In order to enable him to obtain instructions, counsel for the writ petitioner will serve sufficient extra copies within the course of the day.
Number 13.
Page 1. Yes, who appears? None appears. Passed over. MS Purva for CGC.
Government Advocate 2, 3, 5, and 6.
MSG Bora for
Respondent number 7.
respondent 7.
In this case, my petitioner paying appointment on compassionate government.
Hmm?
Appointment on compassionate government.
Compassionate.
Yes. Initially, his mother was.
Heard counsel for parties issue notice returnable 4 weeks. Who is appearing for respondents? MS
Irrigation.
The Neug appears for all.
1, 2, 3. 1, 2, 3.
Huh?
1, 2, 3.
1, 2, and 3. MS Bora for respondent number 4. Since the respondents are represented, notices are waived. Extra copies will be furnished within a period of 1 week from today. Respondents may file the necessary affidavit if so advised. Like list accordingly.
My please, your lordship. Lordship, kindly the matter may be taken after a few minutes. Yes, on my legs.
Passed over. Right. Thank you.
16. What are these cases regarding compassionate appointment? My lord.
Compassionate appointment.
Compassionate appointment, but petitioner has come against the impugned office memorandum dated 18/9/2024. Well, here, my lord, they have mentioned that no cases for appointment on compassionate ground to the family member of the state government employees who died in harness prior to the 31/3/2017.
We'll see that. You'll issue notice at the.
My lord, already that part is over, my lord. There is a.
We'll issue notice. What else is there?
Well, earlier it was decided by the Guwahati High Court. There is a judgment. My lord.
Subsequent, there too, lot of events have taken place.
Maybe,
So at this stage, we can only issue notice. We can only defy your date of dismissal. That's what we are trying to tell you. And I heard counsel for parties issue notice returnable 4 weeks. Mr. G. Pegu, learned government advocate. You're for which department?
My lord, I am for, my lord, 2, 3, 4, 5, and 6.
Appeals for 2, 3, 4, 5, and 6. Who's anyone for education?
Education, my lord.
Who is for school education?
B. Kosik may be recorded on.
B. Kosik is for school education. Since the respondents are represented, notices are waived, extra copies will be furnished within a period of 1 week from today.
Well, look, item number 17 and 18, same something.
17, 18, same order. Same respondents.
Not same, no, same, no, my lord, department is different.
Which department? 17,
17 is PSC, my lord.
Yeah.
Executive Engineer, PSC, Devadu. Public. 17.
17 is
PSC, my lord.
PHE. Who's appearing for PHE? M. Kolita for PHE. Baki kini age time.
And for 18, my lord, irrigation, my lord.
And for 18, M. D. now for irrigation. Rest age time. Yes.
19.
Yes, just
there is an order at page 249. Similarly situated 249.
Yes.
250 is the order that has been passed. They are similarly situated, but somehow they were left out in this group. Finally, see this order, my lord, at 22/1/2025. Affidavit filed.
This matter is pending.
Yes, affidavit has been filed. Am I learned? When it is, reply also has been filed.
Will issue notice in the same line?
Yes, same, and accordingly it will be tagged together.
Heard Mr. D. Das, Senior Counsel, assisted by Mr. K. Mohammed, Counsel for the petitioner. Issue notice returnable 4 weeks. Mr. R.M. Das for
Water resource.
all.
Not all, not
Only
the water resource department.
So
2, 4. I'm appearing for 2 lots. This one.
Mr. A. Chakraborty for 2 and Mr. A. Cholia for 3 and Mr. R.M. Das for all the other respondents. Since the respondents are represented, notices are waived, extra copies will be furnished within a period of 1 week from today. Let this matter be listed together with WPC 136.
136
of 2025.
So protection was there, interim protection, no coercive measure.
Lordship, at least.
No coercive measure, no, it's already there. Same, otherwise, no coercive measure should be taken in the line of same orders. In the, my lord, they may carry.
Same.
Yes, same.
In the next day, investigations may be carried on, but no coercive action.
Yes, that's all. Deeply of it.
Then we'll have to fix a date.
Yes.
3rd of November?
Oh, right.
21.
Lordship, this is regarding disqualification on the ground of height, Lordship, by Staff Selection Commission, Lordship. Lordship have passed an order on 15/9/2025.
Yes, is it
Yes, Lordship.
possible?
Yes, Lordship. On last occasion, another matter has been also disposed by
Your
this
Lordship.
court.
Similar order.
Similar 5411.
Right.
5411.
Council for parties. This order is at page number 57.
No, Lordship,
This order is
not yet made online, Lordship.
Not
But
yet.
this was passed on 15/9/2025 by your Lordship.
not uploaded, Lordship.
Yeah, online one is maintained.
This order was passed on 15/9.
Then let it come on Friday.
Lordship.
Let it come on Friday. We'll get a copy of that order.
Otherwise, I have other orders passed by.
If we have passed an order, let it be disposed of in the same line.
Lordship,
So that there is no contradiction.
Lordship.
Right? Friday.
Lordship, item 23. Okay.
This is item number
This is 21 and 23.
21 and 23
23.
on Friday.
Obliged, Lordship.
Obliged.
You upload one simple order.
My name may be recorded, Lordship.
MSS Borua, State Council.
CGC.
Sorry, CGC, APS for the respondents.
24.
Yes.
Before you actually gonna big agree.
Notice today. Not Mr. A. Sharma. The council to the petitioner. Anyone for the respondents? GMC.
GMC, Nayok.
Mr. S. Bora.
Bora Nayok also there.
Mr. P. Nayak, council appearing for the GMC, respondents 1 and 2. Issue notice returnable 4 weeks. Since the respondents are represented, notices are waived, extra copies will be furnished within a period of 1 week from today. List accordingly. Yes, Mr. Nayak, we are issuing notice?
Yes, Lord.
Please.
25 is same.
All right, 24,
And 25.
24, 25.
Pendency cannot be.
Pendency shall not be a bar to consider the grievances of the writ petition.
Let them
by
wait
the
for
respondent.
sometimes. Otherwise, other petitioners have filed petitions in the year 2023 itself. They
No,
obtained.
we are only saying pendency.
Yeah. Not say. Obliged.
25.
At 25, same.
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 26.
Met prisoners. Lord, here in this case, my lord, my area salary.
Area salary.
Where salary is not paid. Amounting
Issue
to
notice today.
11 lakhs, my lord.
Will issue notice today.
Yes, my lord.
Heard council for parties issue notice returnable 4 weeks. FSM Kavita. Learned council appears for all the respondents. Therefore, notices are waived. Extra copies be furnished within a period of 1 week from today. List after returnable dates. Pendency of the writ petition shall not be a bar to release the salary claimed by the petitioner, by the respondents.
Returnable by 2 weeks.
4 weeks.
Obliged.
Obliged.
27.
Yeah, please. The petitioner also following a due selection process, her name was recommended for appointment to the post of Anganwadi worker in 8 number Balapur Anganwadi Center under Sangha ICDS for that. But because I have passed my lordship, when the minutes were sent for approval lordship, they have doubted my high secondary examination, saying that I have passed my high secondary examination from State Board of Secondary Education, Delhi. So nowhere in the advertisement all on the guidelines lordship, they have stated that only from the high secondary, only from Assam High Secondary Education Council will be accepted. Without any opportunity now,
Where is that advertisement?
Advertisement lordship at page 70.
Annexure 1.
Annexure 1 lordship.
Appointments have been made.
No, Lordship. Page 53, Lordship may kindly listen. I am the only candidate because the other two candidates, their candidates were rejected. I became the lone candidate in that particular center, Lordship. Page 53, Lordship, with these minutes were sent for approval but not approved by the director.
Yes, what do you say?
At this stage, notice have to go, Lordship, but whether these minutes have been under process, maybe.
Lordship, I have an interim prayer, Lordship, not to re-advertise the post, Lordship. Because I am now the lone candidate. 3 candidates applied, Lordship. 2 candidates, their candidates have been rejected. So my name was
Short time may be granted, Lordship. I have to take instruction.
When can you get it?
Next week,
Next week?
yes, Lord,
Which day?
by Tuesday or Wednesday.
Tuesday?
Wednesday, Lordship. 23.
23. All right, 23. Heard counsel for parties. Petitioner is agreed by her non-selection to the post of, by her rejection of her candidature. The post of Anganwadi.
no, Lordship. I'm not approval, Lordship. I have been selected. My name has been forwarded.
Okay.
Forward now.
Non-approval by the director.
The petitioner is agreed by the fact that her selection has not been approved by the competent authority for appointment in the post of
Anganwadi worker in 8 number Balapara Anganwadi.
Anganwadi worker in 8 number Balapara
Anganwadi, under Senga ICDS was.
under Senga ICDS project in the district of Borpeta. Learned counsel for the petitioner submits that this approval was not granted only on the ground that the petitioner completed her high secondary examination under the Delhi State Board. It is submitted that the advertisement does not debar candidates having educational qualification from other states. Therefore, the rejection of the petitioner is without jurisdiction and discriminatory. Stop. It is further submitted that in total 3 candidates had appeared, and all the other 2 candidates have also been. Petitioner is the only candidate selected. Para S. Borua, learned government advocate, submits that she would like to obtain instructions in the matter. Is agreed to let the matter be listed on 23rd.
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 All right.
Obliged.
Please serve extra copies
Possibly.
by the course
Yes.
of the day.
Pray for compassionate appointment.
Another case for dismissal.
No, my lord, there are some features of this case, my lord. In fact, my lord, I had applied within the prescribed period of 1 year of my husband's death. And my
No,
lord,
but
received.
you have to now apply in terms of that executive order
Milord, I have applied for the second time in the year 2021. That was
Right,
rejected.
we'll
in
issue
2000.
notice.
No, Lordship, he has,
No notice.
he had, Lordship, in the case, Lordship, he has challenged the DLC rejection order, Lordship.
Ah.
After that, Lordship, after the new notification has come, 18/9/24, all the rejection and orders are, Lordship, infructuous, Lordship, has become infructuous. The new OM has come, Lordship. That OM has still existence,
I
Lordship.
applied
You
for
bring
the
it on
first time in
record.
15.
You have to bring it on records once.
Let them file the affidavit, then I will do the needful. Let them place on affidavit. If there is an OM to be challenged, we'll do that.
He must challenge the
I
OM
will
dated
challenge it.
18/9/24.
I applied in 2016 for the first time, Malons. No information, Malons, for 5 long years.
Yes, now he has come before the court, Lordship, on the rejection of DLC, Lordship.
See, we are not supposed to apprise you.
Lordship.
It is the other way around. You are supposed to apprise the court. But there is an office memorandum
Lordship.
which has put a stop to all compassionate appointments.
That is there.
If you are not aware,
No, that
then
is
it
there
is
in
your
the
duty to become aware and take steps, whatever is to be done.
Lordship.
Now, unless that is put to a challenge, to decide anything on merit would be meaningless.
What has happened in this case is that for the first time I applied in 2016.
Whatever you may have done, but this office memorandum puts a complete stop. Subsequent thereto, there have been several orders. So, therefore, you may like to find out what developments have taken place and then decide whether to proceed in the present form or
to amend or file.
whatever you want to do.
Lordship. Lords will have it perhaps next.
But because you see, if we issue notice in this form, it will get supplemented by additional affidavits, which will make things difficult.
Yes.
So your core issue is that you were selected by DLC, not considered thereafter.
No, I was never selected.
Recommended by DLC.
Rejected by the DLC.
rejected.
And, Malad, that was the second time. In 16, I applied, Malad. I was communicated anything about that rejection, acceptance, anything. No, nothing.
Then?
And Malad, for the second time, then again I replied. Lord, you will kindly have for a minute, Malad. This is at page. Malad,
What is your prayer here?
Malad, my prayer is to consider my case for compassion appointment on the ground of my first application in 2016. Malad.
Which, according to you, was rejected.
Rejected, Lord.
No, Malad.
That
Let me
DLC
submit, you submit. Well, Lordship will kindly have page 18 for a minute. Because I applied within the prescribed period of 1 year of my husband's death. And the second rejection is erroneous. Lordship will have this letter, Manoj, because I do not have, Manoj, I have stated with fairness that, Manoj, we do not have a copy of the original application. This is a reference to that application, Manoj. 4/7/2016. My compassion appointment application was forwarded by the Commandant 10th Assam Police Battalion to the Home Department. And it makes a reference, Manoj, that I have submitted my form along with all necessary testimonials. This is of July 2016, less than a year of my husband's death. But this, Manoj, after this application, I received nothing, no information whatsoever. So I applied again, Malad. Lord, you will kindly have the next page, Malad. Page 19. And in this application also, my second application, I have made a reference that I have applied earlier. This is the letter.
Then?
So, Malad, in view of my previous application, what was the fate of my previous application? Let them at least bring that on record.
That you should try to get it through their other means to do
Look,
it.
That, Malad,
You can't file a writ petition to secure the information from the
no,
department.
I'm not securing information, Malad, but my second application, Malad, was rejected. The ground of rejection, if your lordship will come, the minutes of the meeting held on 26/9/2022, which is at page 20 onwards, Malad. Your lordship will have page 21, the column number 5. Your lordship has, the office of the commandant so-and-so. The proposals of the following candidates received from the concerned department were taken up for consideration. My name is at serial number 2. On scrutinization of the above proposals, it was observed that the proposals had been rejected in earlier DLC meetings. I am not aware, Malad. For moreover, as per
you are not aware, cannot be a right crystallized.
Lordship will see the next part, Malad. Moreover, as per the information received from the concerned department, the candidates had not applied within 1 year from the date of death of the government servant. Hence, the above proposals could not be recommended. This ground itself is an erroneous ground. I have applied within 2016.
That's right. But what has happened to that?
That is why we were never communicated about that.
You were never communicated from 2016. Why did you wait?
And 2021, my lords, when I make them my second application, I have said that, look, I've applied for, this is the letter reference number.
Mr. Ganguly, if you are, you see, this High Court is not,
I
can't,
understand
can't
what your
operate as
lordship is
a
indicating. In that
public
case,
information
In
office.
that case, my lordship will perhaps consider issuing notice. In the meantime, I will apply under the prescribed. My
No,
lords.
we'll not consider issuing notice. You get these instructions, why, what has happened to your application, why you did not come to the court from
I'll
2016
make that
onwards.
application to the.
Why have you not
department
done
first.
it? Where is your explanation that from 2016, what happened?
No, I have explained that, my lord, in para number 6, my lord.
What happened from 2016 onwards?
In para number 6, my lord, I have made that application. In fact, para 5 onwards, my lord.
Why
Para
should we
5
not
is-
dismiss it on the ground of laches?
Not latches, my lord, in my humble submission, my lord, the very ground for rejection being erroneous, the ground in.
What is the ground for erroneous?
Well, because my second
22,
application.
we're not even considering 22. We are saying that your 16 application, you are not aware.
No,
You are essentially trying to come to this court to get an order directing the department to produce what happened in 16.
In that case, my lordship will allow me
Yes
time to
or
file
no?
an additional affidavit.
No. Why should we?
To include whatever.
No. Why should we?
Because it is necessary to bring the 16, the fate of the 16
No,
application.
15, then you should have brought it in the writ petition itself.
No, in fact, with this present.
You are
application-
challenging the second rejection on the ground
Lordship.
that there is a error in their perception that you had applied after 1 year, when you had already applied.
Yes.
What happened after you had applied?
No, that is the.
What
it's a
steps
fact,
have
my
you
lord.
taken to pursue?
Lord, she has made personal visits and all, my lord, that is there.
That is
Under
the end of
RTA
it.
Act, my lord, no
That's
application.
the latches. That's the latches.
That perhaps would not. my lord.
And 22 also, you're coming in 25 after 3 years.
Yes, my lord, because my lord, we have come to know only in the month of August 25.
We are dismissing your petition.
Lord, lordship will allow me to place that information under the RTI Act, lord.
So whatever you want to do, but not like this. Not like this.
Because we'll file an additional application.
No. We are not permitting you to file an additional affidavit. We are dismissing it unless you want to withdraw.
No, then that liberty may be given to approach
Third
again.
counsel for the parties, this writ petition is filed. Putting to challenge an order of rejection of the prayer for compassionate appointment by the DLC. Passed on 26/9/2022. Learned counsel for the petitioner, referring to the minutes of the DLC held on 26/9/2022, submits that insofar as the writ petitioner is concerned, her case along with 2 others was rejected by the office, was rejected by the DLC on the ground that the candidates had not applied within 1 year from the date of death of the government servant. The learned counsel for the petitioner submits that the petitioner's name appears at serial number 2 of the minutes, and she did apply immediately after the death of her husband, who died in harness. When did he die in harness?
It was 22/11/2015.
On 22/11/2015, and the petitioner applied for compassionate appointment immediately thereafter. However, she does not retain a copy of the application file, but the respondents did not communicate to the petitioner about the status of her application filed. Therefore, she made a second application, which came to be rejected on 26/9/2022. On the grounds that it was the application was made after 1 year, beyond 1 year from the date of death of the government servant. Stop. Para Mr. A. Chakraborty, learned counsel for the respondent, on the other end submits that his writ petition is not maintainable on the ground that the notification office memorandum dated 18/9/24 issued by the personnel department.
Personal department.
Whereby compassionate appointments have been completely have been done away with by the government of Assam. has not been put to challenge. Thereafter, several orders have been passed and pursuant thereto, executive order dated 3008-2025, read with a notice dated 3008-2025 have been issued by the department. So all these cases were required to be considered on the basis of the particulars filed in terms of the notice dated 3008-2025. And the last date for filing these particulars of persons aggrieved in terms of the executive order dated 3008-2025, was on 15/9/2025, and which date has already expired. Stop. Under such circumstances, there is no merit in the petition and the same should be dismissed. Well, having noted the submissions made before this court, it is also apparent to the court that the petitioner essentially in the present proceedings is putting a challenge to the rejection of her prayer for compassionate appointment by the minutes dated 26/9/2022, wherein, insofar as the writ petitioner is concerned, her case was rejected on the ground that the application for compassionate appointment was filed beyond 1 year after the death of the government servant. Stop. The case projected on behalf of the petitioner is that this finding is incorrect, as the petitioner had already applied immediately upon the death of her husband before the competent authority for compassionate appointment. Stop. Her case, the status of her case was never communicated to the writ petitioner. Stop. Therefore, the finding of the DLC in a minutes dated 26/9/2022 that the petitioner had applied after expiry of 1 year is incorrect. Stop. These submissions cannot be accepted in the absence of any specific averments made in the writ petition as to what steps the petitioner undertook to pursue the application stated to have been filed within 1 year immediately after the expiry of her late husband on 22/11/2015. Stop. There is no averment to that effect, save and except a bold submission that the petitioner had been pursuing her application. Stop. Under such circumstances, this court is not inclined to entertain the writ petition in the present form. Writ petition accordingly stands dismissed on the ground of delay and laches. Even otherwise, the order of rejection of the second application, which was issued on 26/9/2022, has been put to challenge in the year 2025. Stop. Writ petition accordingly dismissed. The dismissal or rejection of the writ petition will, however, not be a bar to the petitioner to pursue her claims before the department in respect of the first application stated to have been submitted by the writ petitioner within 1 year pursuant to the death, expiry of a late husband on so-and-so 2015. Discourse.
God bless.
I think dwelling
Please, Your
Yes.
Lordship, the council is engaged in another court.
Huh?
The council is engaged in another court.
Friday. Yes. List on Friday.
30.
Wait, please, Your Lordship. Lordship, here are two petitioners. Petitioner number 1 is the surviving first wife, and 2 is the second wife, my lord. Their husband was
Full bench judgment?
my lord.
Then
In full bench, my lord, it also in paragraph 23, that is space 39. It is also said that, my lord, there is no bar if the government under in acceptable circumstances then can provide.
have you filed any application?
I have filed page 44, 47, 52.
Please consider the application.
Page 44, my lord, to the
How
joint.
many applications have you filed?
Page 44, it was filed on 11/4/25 to the Joint Director Health Service. Then page 47, it is filed on 25/6/25. Then, my lord, page 52, it was filed to the Commissioner Secretary, Government of Assam.
Why don't you consider these representations?
At this stage, Lordship may issue notice, Lordship.
All right, Art Council for Parties issue notice, reasonable 4 weeks. Ms. D. Bora, Learned Council for the Health Department, accept notice on behalf of respondent 1, 4,
1, 4,
5,
5, 6, and 7.
7. And Mr. B. Sharma for respondent number 2 and MSS Bora for respondent number 3. Since the respondents are represented by the council, notices are waived, extra copies be furnished within a period of 1 week from today. List after return date.
My lord, here, page 52, the representative may not be barred to consider during the pendency.
Pendency of the writ petition will not be a bar to consider and dispose of the representation.
Dated 28.
Stated to have been filed by the petitioner.
Date-
Representation dated
28/8/2025.
28. Representations, we are saying representations filed by the petitioner,
Dated.
which are enclosed in the writ petition.
The first one dated 11/4/20.
Oh, we have stated that enclosed to the writ petition, that's all.
I am deeply.
Extra copies to be given.
31.
May I please, Your Lordship, the matter relates to selection of Anganwadi worker, Lordship. In this matter, the petitioner, after applied for the advertisement of the Anganwadi worker, was selected, and his selection was made in page number 41, Lordship, Annexure 5. After that, she was not allowed to join, Lordship. But again, another application, another result was declared. Second result was declared on 12/8/25, Lordship, which is annexure number 6. And after that, Lordship, respondent number 7 was allowed to join instead of the petitioner, Lordship.
Then
Then, Lordship, the petitioner applied for the representation. He made his representation, which is annexure number 9, Lordship, page number 45, Lordship, before the respondent number 6, to consider her
we'll issue
prayer.
notice at this stage. Third council for parties issue notice then about 4 weeks. Mr. Mr. J.K. Goswami.
1 and 2, Lordship.
Respondent?
1 and 2.
1 and 2, Mr.
Others.
Musari for 3, 4.
3, 4, 5, and 6.
3, 4, 5, and 6.
Argument, sir.
Since the council represents respondents 1 to 7, notices are waived, extra copies be furnished within a period of 1 week from today. Steps on respondent 7 by registered post ID as well as legal course within 1 week from today.
Lordship,
Is after returnable date, pendency of the writ petition shall not be a bar to consider the claims of the writ petition by the respondents.
My pleasure, Lordship. Lordship, my senior has some personal difficulty. Kindly pass over the time.
Friday. Friday.
33.
On the request of council, it is tentative, but released it on Friday. Yes.
Petitioner hearing. Lordship, before starting my this is the matter pertaining to civil bench 2.
Civil bench 2?
Yes, Lordship.
Yes, my lord, another application is pending before the bench too, my lord. Why this is listed before this bench, I don't know.
All right, counsel for the parties submit before the court that a similar matter filed. But as a matter filed by another similarly situated person. What is the number?
Same person.
Huh?
Same person.
Same person.
My lord.
By this writ petition filed by the present petitioner, earlier writ petition being WPC number
Yes, my lord. 2313
2313
of 2025.
of 2025 has been placed before civil bench 2.
Yes.
Notice whether issued.
Issued, Lordship, we
My
have
lord, that is
submitted affidavit in opposition also.
Notices are issued and the matter is pending disposal before civil bench 2. Registry is therefore directed to examine and place this matter before the appropriate bench.
My lord, on Friday, my lord. I have urgency, my lord.
Lordship, Friday.
Otherwise,
Let the registry endeavor to list this matter on Friday.
Lordship, Friday, I have difficulty. I have already told Monday.
you are not the important. The education department is the main
Monday,
respondent. my lord.
If he agrees, we have no difficulty.
No,
If
Monday
he doesn't agree, we can't compel him to agree.
My addendum has been challenged and he said that I am not important. Lordship, Monday, Lordship.
He doesn't agree, then what can we do? He is the petitioner.
Monday, bro.
By the time.
Monday, five on.
Let it
Okay, Lordship, let it Friday, Lordship.
Friday.
Friday, Lordship.
Friday.
As he is not consenting, let it Friday, Lordship. But I have difficulty. How about you?
Please, Lordship.
Yes.
My lord, initially the penalty was imposed was withholding of 3 increment, my lord. Kindly come to page 153, my lord. Page 153. The penalty order is 8/6/2023, my lord. And my lord will kindly turn to page 154, the next page, my lord. And your lordship will see at the bottom, the penalty was decided by Commissioner and Secretary to the Government of Assam, Medical Education and Research Department. And penalty was, my lord, withholding 3 increment, minor penalty under Rule 7(2), my lord. Thereafter, my lord, they did not serve us a copy. We filed RTI and we procured a copy and we filed a departmental appeal on 1/8/2023. Thereafter, my lord, on 4/12/2023, my lord, I was appointed as a professor of Dhubri Medical College. I was promotion, my lord. Now, since, my lord, 2 years had elapsed and there was no positive action forthcoming from the government, we are compelled to file a writ petition. And this is what happened on the first day of listing, page 165, my lord. If your lordship kindly turns to 165, your lordship's own order is there, my lord. 3rd paragraph, my lord. At this stage, Learned Counsel Health Department will obtain instruction as to the status of the appeal stated to have been preferred by the petitioner. And the matter was listed on, my lord, 22/8/2025, my lord. Now, if your lordship kindly turns to page 167 for a moment, that is the order of 22/8/2025, the 2nd paragraph, my lord. In deference to the order dated 4/8/2025, the Learned Standing Counsel Health Department on instruction submits before this court that the appeal preferred by the petitioner is under consideration and is presently in the final stage of disposal, my lord. And this was the instruction and matter was fixed on 15/10/2025, right after reopening. In between what had happened, my lord, the respondent number 2 sat over his own appeal and he enhanced the penalty, which my lord will find.
Which respondent to?
He is the Commissioner and Secretary to the Government of Assam Medical Education and Research Department, my lord.
He is the disciplinary authority.
He is the disciplinary authority.
He reviewed his own.
Once I came before this honorable court, he sat over the appeal against his own order. And this is what he had to say. It starts at page 168 and the operative portion, my lord, will find at page 171, my lord. The last paragraph, my lord. Page 171. Now, therefore, considering all material facts and circumstances, Governor of Assam is pleased to reject the appeal petition submitted by Mr. Jagannath Pator and hereby
appeal was preferred before whom?
The appellate authority.
Who is the appellate?
That appellate authority, my lord, will find my appeal, your lordship will find at page 158. Page 158, my lord. I had addressed it to appellate authority and they had forwarded it to the...
Who is the appellate authority?
That my learned friend will...
Who is the appellate authority?
But it is the governor.
Governor.
Yes, schedule manner, both manner.
All the orders. Both the orders were in the name of the governor, my lord. Both the orders, both the penalty order as well as the appellate order.
What order was passed by the governor? Rejecting?
Yes, No, regarding that authority part, he's questioning the
Now-
authority, whether my lord, same person can pass it on. Lordship will see the my lord, rules in that case.
I'll place the rules.
Yeah.
man.
All right. Yes, tell me.
So page 171, what all orders are in the name of the governor under Article 162, page 171. Now, therefore, considering all materials and circumstances, Governor of Assam is pleased to reject the appeal petition submitted by Jagannath Patar and pleased to enhance the penalty of withholding 3 increments with cumulative effect under Rule 7 to reduction to the next lower post as per Rule 7.4. That is a major penalty. Consequent upon the issuance of this order, Dr. Jagannath Patar is hereby posted as Associate Officer, Department of So-and-so, Dhubri Medical College, and is released from the post of the professor. So, my lord,
He is, this is an order of the appellate authority.
may I just point out one thing, my lord? Both the orders were in the name of the governor, both the penalty order as well as this appellate order. But the person who had decided is the commissioner and secretary, respondent number 2.
No. Appellate authority has to be the
And
governor.
if I may just point out
This
the
is under
rules.
what rules?
But in the Assam Service Discipline and Appeal rules. Lordship will see the schedule, my lord. Serial number 23. Gazetted officers under Health and Family Welfare Department. My lord, 1 appointing authority governor, appellate authority governor. For gazetted officers, my lord, this is the situation.
Now, if your lordship kindly turns to section, well, Rule 23, which deals with the consideration of appeal, my lord. Rule 23, consideration of appeal, and the proviso to the rule, proviso number 4, my lord. It states, in fact, if your lordship kindly comes to Rule 23.2, in the case of an appeal against an order imposing any of the penalties specified in Rule 7, the appellate authority shall consider A, B, C, D, and the proviso 4, it says in the next page, no order imposing an enhanced penalty shall be made in any other case unless the appellant has himself given a reasonable opportunity as far may be in accordance with the provisions of Rule 9 of making a representation against such enhanced penalty. So this proviso to Rule 23 makes it crystal clear that before enhancing a penalty, the appellant has to be given a reasonable opportunity as may be in accordance with provision of Rule 9. Rule 9, my lord, makes it clear they have to give a show cause and the other procedural safeguards are there of making a representation against such enhanced penalty. In this case, my lord, I was not even put to notice that they are seeking to enhance my penalty. Had they dismissed my appeal, my lord, and my lord,
rejection is one thing.
Well,
Mere dismissal is one thing.
then I will satisfy your lordship, my lord. From
but-
this proviso itself, my lord. I will satisfy.
Yes.
now, my lord, had they dismissed my penalty, then they did not give me a notice. But the moment they enhanced the penalty, my lord,
All right.
And-
Anything more?
and my lord, only one thing, if your lordship kindly sees page number, my lord, the penalty order at page 154, my lord, kindly, my lord, for 1 second, my lord, page 154, my lord, the second last paragraph, my lord, page 154, this is the penalty order dated 8/6/2023, my lord. Kindly see the second paragraph from bottom. Now, therefore, the governor of Assam is pleased to accept the report submitted by the inquiry officer and impose the penalty of withholding 3 increments with cumulative effect under Rule 7.2 of the Assam Disciplinary and Appeal Rules 1964 upon Jagannath Patar. Even the penalty order is in the name of the governor. And below, my lord will find series one gentleman called Mr. Siddhartha Singh, Commissioner and Secretary to Government of Assam. Now, if your lordship kindly comes to 171, a conjoint reading of 154 and 171 will make things clear, my lord. Now, 171 also, if your lordship sees the last paragraph. Now, therefore, considering all the materials and circumstances, it is pleased to reject the appeal petition submitted by Jagannath Patar, is pleased to enhance the penalty as per so and so, my lord, and consequent upon is be posted by order in the name of the governor. And below, my lord, the same authority, Dr. Siddhartha Singh. So, therefore,
That's what the rule say.
that's what the rule says, my lord. Now, what the rule says,
Your only ground for objection is that before enhancement of penalty, you are not put to notice.
we are not put to notice. That is
Issuance of this is
And-
as per the rules.
That is first ground, my lord. And second ground, my lord, Both the orders are in the name of the governor.
That's
But
what the rule says.
But the authority which has, my lord,
Whatever it may be.
This Siddhartha
That's
Singh
what
cannot-
the rule says.
That is what the rule says. But my lord, rule also says the rule of bias. Now this Siddhartha Singh.
You have not challenged the rules. The rules say that for these orders, as per the schedule, the same authority.
But in my case, the order who had imposing the discipline authority himself was the commissioner, my lord.
Why are you
these are
reiterating the same?
These are
This is what
brief
the rule
points.
says.
These are the brief points before your lordship.
Unless you challenge the rules or you interpret that, no, this is not what the rule says. The parent rule says something, the schedule says something. It's not like that. Your grievance is that before reduction, you ought to have been put to notice.
That is number one.
The lordship may see rule 23. 23(2). It says in case of an appeal against an order imposing any of the penalties specified in Rule 7, the appellate authority shall consider. Then, my lord, after A, B, and C, and after consultation with the commission, if such consultation is necessary in case, pass orders 1, Roman 1, setting aside, reducing, confirming, or enhancing the penalty. So here in the present case, it has been enhanced. Provided that, now lordship will see, provided that number 3, my lord, Roman number 3, if the enhanced penalty which the appellate authority proposes to impose is one of the penalties specified in clause 6 to 7, that is a major penalty.
4 to 7.
Sorry, 4 to 7 of Rule 7, and an inquiry under Rule 9 has already been had in the case. The appellate authority shall make such order as it may deem fit. Here, my lord, after conducting the inquiry, this was done, my lord. Now, 4. No order imposing any enhanced penalty shall be made in any other case unless the appellant has been given a reasonable opportunity so far as may be in accordance with the provision Rule 9, so and so, so and so. So, in the present case, it was conducted, my lord.
What was conducted?
Well, the department proceeding under Rule 9, my lord, entire proceeding was.
So this 23 is a consideration of appeal of what? 23
lordship
is consideration of appeal against what? Orders passed by the disciplinary authority.
No, yes, but lordship, so far as the, my lord, particular, my lord, present case is
You are
concerned.
saying that in so far as 23(2)(3) is concerned,
my lord,
where the punishment imposed is 4 to 7.
Then lordship will see 2 also, Roman 2. If the enhanced penalty which the appellate authority proposes to impose is one of the penalties specified in clause 6 to 7 of Rule 7, and an inquiry under Rule 9 has not already been held in the case, the appellate authority shall, subject to the provision of Rule 10, itself hold such inquiry or direct such inquiry to be held in accordance with the provision of Rule 9, and thereafter, on consideration of the proceeding of such inquiry, make such orders as it may deem fit. In the present case, my lord, since it has been held, my lord, already inquiry has been conducted, so it will come under Rule 3, Roman 3.
No.
Proceeding under, my lord, 9.
No. See.
For imposing penalty under Rule 7.
Number 1, there is a charge sheet issued, proceed
Yes.
for inquiry.
Yes.
Inquiry completes.
Lordship.
Submitted to the disciplinary authority. Disciplinary authority may accept, may not accept.
Lordship.
Then this Rule 9 will come, Rule 9(a).
Yes.
That if they disagree, disagreement note, etc.
Lordship.
Now the purpose of these rules is that you give an opportunity to the person to ventilate his grievances. You have, on the first hand, you have accepted the fact that it is the same authority who is the appointing as well, disciplinary as well as the appellate authority.
That is, my lord, one way, but my lord, going by this particular, my lord, provisos, it's very clear, my lord.
We'll examine it.
Yes, lordship will have to examine it. Otherwise, my lord, there is no such authority as on that, my lord, to place that, my lord.
This writ petition has been filed by the petitioner, aggrieved by the impugned order dated
2/9/2025. Page 168, 2/9/2025.
You are aggrieved by 8(9).
8(9) already, 8(6) I have already challenged.
8(6).
That in the first round of litigation already challenged. And this is the second.
All right.
During the pendency, second order.
is agreed by the order dated where is the date of the order?
My lord, that date of appellate order, penalty order or appellate order, my lord?
Penalty,
Pen- 29, my lord.
2/9/2025, issued by the appellate authority, whereby the punishment earlier imposed by the disciplinary authority stood enhanced. Stop. The petitioner was proceeded with pursuant to departmentally pursuant to issuance of show cause notice, and after completion of the proceedings, the disciplinary authority imposed what was the punishment imposed? Withholding 3 increments.
Withholding of 3 increments, my lord.
With cumulative effect under Rule 7(2) of the Assam Services Discipline and Appeal Rules, 1964. Stop. The petitioner preferred an appeal, which however came to be rejected by the impugned order dated 2/9/2025. And besides the appeal being rejected, the appellate authority enhanced the punishment to, within quotes, reduction to the next lower post, as per Rule 7 within bracket 4 of the Assam Discipline and Appeal Rules, 1964. Pursuant to this order, the delinquent employee, namely the writ petitioner, is posted as was released from the post of Professor, Department of Obstetrics and Gynae, DMC and H. Dhubri, and was posted as Associate Professor, Department of ONG, Dhubri Medical College and Hospital. Stop. Where counsel for the petitioner, referring to the Assam Discipline and Appeal Rules, submits that under Rule 23, 2, within brackets Roman 4, where the punishment is required to be enhanced by the appellate authority, the rule mandates a reasonable opportunity to be granted before enhancement of the penalty. Stop. He submits that this opportunity was not granted, and unilaterally this punishment imposed was enhanced, and therefore the petitioner is before this court praying for appropriate orders. Mr. B. Gogoi, additional AG, representing the state, disputes the contentions of the petitioners, the petitioner. He submits that Rule 23 has to be read together, and if the entire provisions are read, then Rule 23(2)(4) is an exception to the Rule 23 2 within bracket 1, then 2, then 3. Roman 1, 2, 3. Stop. He submits that where an inquiry under Rule 9 has already been conducted and disciplinary authority has imposed punishment, there is no need for issuance of prior notice by the appellate authority. As sought to be contemplated by the counsel for the petitioner. Stop. There's one more submission we missed out of the petitioner. Note down. Petitioner submits that both the disciplinary authority and the appointing authority are one and the same person, and the writ petitioner had earlier approached his court by filing WPC number so and so, assailing the imposition of punishment by the disciplinary authority, while also preferring an appeal before the appellate authority. Stop. During the pendency of the writ petition, the appellate authority came to issue the impugned order, and it appears that the disciplinary authority and the appellate authority are one and the same person. Therefore, the disciplinary authority, acting as the appellate authority, ought not to have issued the impugned order during the pendency of the writ petition, earlier writ petition being WPC so-and-so, which had assailed the orders passed by the disciplinary authority. This is the submission of the petitioner. Come to the contentions of the respondent. The learned additional lady further, referring to the rules, submits that as per the schedule enclosed at serial number 23, in respect of all gazetted officers under the Health and Family Welfare Department, the appointing authority and the appellate authority are shown to be the governor of the state. Stop. Under such circumstances, in the facts of the case, the punishment was imposed by the disciplinary authority, who is also the appointing authority, and the appeal which was preferred by the petitioner against the order of punishment imposed by the disciplinary authority was disposed of by the appellate authority, who is also the governor of Assam, by the order dated 2/9/2025. So therefore he submits that in terms of the rules, the rules are not put to challenge, and therefore in terms of the doctrine of necessity, as is prescribed under the rules, there is no infirmity in the orders passed by the appellate authority. Having heard counsel for the parties, it is seen that the rules, the schedule appended to the rule, prescribes the appointing authority and the appellate authority to be the governor of the state, insofar as gazetted officers and the Health and Family Welfare Department are concerned. So, under such circumstances, prima facie, this court is of the view that unless the provision is specifically put to challenge, the claim of the petitioner that the order of the appellate order impugned in the present writ petition would not have been passed by the same authority. So, insofar as the second submission is concerned, referring to Rule 23, it is seen that Rule 23 2, numerical 2, within bracket Roman 4, prima facie appears to be an exception to the provisions of Rule 23 2, Roman 1, 2, and 3. Stop. However, going through the provisions of Rule 7 and with Rule 9 and 9 capital A and 10, it is clear that every stage delinquent officer is permitted and afforded an opportunity of representation before any punishment is imposed. Even in case of the departmental disciplinary authority disagreeing with the findings and conclusions of the inquiry officer, a disagreement note is to be issued under Rule 9 capital A before the disciplinary authority can proceed to impose punishment contrary to the conclusions of the inquiry officer. So, considering all the submissions, this court is of the view that the interpretation of Rule 23 2 4 will be necessary to be undertaken by this court. Therefore, at this stage, this court is inclined to issue notice. Let notice issue, returnable 4 weeks. Mr. P. Gogoi, an additional AG, appears and accepts notice on behalf of all. Since notices are issued, since the respondents are represented, notices are waived. Extra copies be furnished within a period of 1 week from today, or 2 working days. Also heard on the interim prayer. This court is of the view that natural justice is one of the core principles envisaged under the Constitution, and all laws and rules and statutes made by the state must be subservient to the basic principles of the Constitution. So, prima facie, this court is of the view that the principle of natural justice must be infused in all statutory rules framed by the state, even if it is not specifically expressed.
Regarding interim part, if lordship is hearing, my lord, then because I would like to place judgments in that regard. It cannot be, my lord, the final order can be passed at the interim stage. My lord.
We are not passing a final order. We are
My
only
lord,
passing
regard-
an interim order.
No, even interim, my lord, because lordship he has been demoted. If that is stayed, my lord, ultimately that amounts to be issuing a final order, my lord.
How can it be?
The
I will place judgment, my lord, if lordship.
is of the prima facie view
I have
that
maybe considered
the
next step.
impugned order prior to passing the impugned order, notice ought to have been issued on the delinquent officer. Under such circumstances, this court is of the view that till the next date fixed, the impugned order shall not be given effect to the extent of enhancement of the punishment.
Well, how my lord, that can be passed, my lord? That amounts to granting a final relief. I would have placed
Can
that.
it be amounting to
No,
grant
lordship,
final
he
relief,
would
my
have-
lord?
he
This
should
is
have
an
played
interim
for
order.
interim,
Your
my
lordship will decide on the interpretation.
We are not granting a stay. We are saying till
Exactly.
the next date. Don't give effect. We are
Obliged.
not granting a stay.
Well, same, my lord, it would amount to, my lord, giving,
can it
my lord,
be-
allowing him to continue in that post, my lord, though he has been demoted, my lord. Now, tomorrow, if lordship holds that, my lord, yes, we are justified
They're not
in
giving
giving
effect
that
to my-
penalty.
And your lordship will
Will
decide.
it be possible, my lord, to, my lord,
Obliged.
my lord, reimburse all the amounts that he will get in the higher post, my lord? That's why, my lord, usually, my lord, in this sort of cases, my lord, the Honorable Supreme Court has held, my lord, not to issue such order. Tomorrow, he can be given all the benefits, my lord. If at all lordship finds that, my lord, yes, he is entitled.
No, I
We
have
were
made
wrong,
a
my
prima
lord.
facie case. Your lordship has already
No,
dictated the
if
order.
that be the issue, at least I should have, I would have placed the, my lord, judgments, my lord. I have brought them.
And prima
At
facie,
least
there
notice
is no
on the interim
notice.
may be issued, my lord.
We have issued notice on the interim.
Yes.
But if
Till
it
the
is
next
state,
date.
Till that they'll not give
even
effect.
then, my
That's-
lord,
It will
even
balance
then,
the equities, my lord.
You argue your matter. If you want to argue, you argue.
no,
your matter.
lordship,
We'll
next
hear it.
argue koro. To be quoted, please move forward.
If you want to argue the matter, if
No,
you have
my
judgment,
lord, lordship will kindly consider is the issue whereby a penalty has
we
been
are giving a
imposed.
prima facie view. That's all. We are only giving a prima facie view.
But my lord, if at this stage it is stayed, that's why I'm saying, my lord, in case of suspension, termination, and
Whatever it may be, it is a question of, this is not a case where, you see, this is a case where you have already imposed a punishment. He is putting a challenge to the same which is
my lord, the
pending in the
rule is
writ
very
petition.
clear, my lord. Rule says, my lord, that if at all there was a, my lord, already inquiry held under, my lord, 9. In that case, it is not necessary, my lord. The proviso number 2, lordship will see what is the purpose of giving the proviso number 2 in that case, my lord, if 3 is not required.
Proviso 4 makes
For
it
a
ex-
moment, my lord, just because it is there in the rules, my lord. I would not have, my lord, otherwise insisted, my lord. Even after passing on the order.
Yes.
And lordship will see for a moment, my lord, because
Yes.
it's very clear. Lordship will see 2. May I read from 1? Provided that the appellate authority shall not impose any enhanced penalty which neither such authority nor the authority which made the other order appealed against is competent in case to impose. Second, if the enhanced penalty which the appellate authority proposes to impose is one of the penalties specified in clause 4 to 7 of Rule 7 and an inquiry under Rule 9 has not already been held. In the case, the appellate authority shall, subject to the provisions of Rule 10, itself hold such inquiry or direct that such inquiry be held in accordance with the provision of Rule 9. And therefore, on the consideration of the proceedings of such inquiry, make such orders as it may deem fit. Here, my lord, had my lord that inquiry be not been held, then my lord, we would have required to hold the inquiry, my lord. Now 3 says, if the enhanced penalty which the appellate authority imposes proposes to impose is one of the penalties specified in clause 4 to 7 of Rule 7, and an inquiry under Rule 9 has already been held. In the case, the appellate authority shall make such order as it may deem fit. It's an appeal, my lord, only. 4 says, no order imposing an enhanced penalty shall be made in any other case, my lord. Here, my lord, there is an order, my lord, already passed by holding that inquiry under, my lord, Rule 9. And one penalty was imposed under, my lord, Rule 7. So that inquiry is here. That's why he says, my lord, proviso 4 says, in any other case, then we'll have to give an opportunity. We are only going by whatever records are there. We are not, my lord, imposing something new. My lord, evidence in this particular, my lord, while imposing this particular, my lord, penalty. That's why I am saying, my lord. 2 and 3 is very clear. 2 says, my lord, if
We will
there-
examine the matter.
Let them file the affidavit, we can fix.
My lord, that's why Lordship will
On the next
consider
day,
the entire
the matter
inquiry on the
will
next
be
day.
disposed of.
Lordship will, let it be in next week also, my lord. I will come up with all the records. Lordship will see. I will satisfy your lordship, my lord.
You satisfy us, we'll fix a date next week if you
Yeah,
want.
that's why I'm saying, my lord. Till that time, that may not be granted, my lord. Let it remain, my lord. Lordship
We
will
are not
consider.
saying don't give effect. We are not staying it.
Exactly.
We
That
are
is
not
the point.
staying it.
Well, if it is given effect, my lord, ultimately not given effect, he will be in the, my lord, higher post.
What, has it been relieved now?
Lordship
No.
will see.
Has it been relieved?
My lord, the order is there. Why is the question of relieving, my lord?
No. What is the present status today? Has it been released?
My lord, where is the statement that he has not been released? I can have the instruction, my lord.
You get the instructions whether.
So lordship will kindly see, he has been, my lord, demoted to a, my lord. And it's not that he has been sent to some other college.
No, that's all right.
The order is there, and this order is of 9-2 or 2-9.
2-9.
Today, my lord.
And
That's why I say,
Thursday,
otherwise, lordship
served the
can, my
copy.
lord, revert back the entire
You
clock.
already joined.
no, my lord. I have not given our charge. Kindly see, my
My
lord,
lord,
page
there is
26.
Issue of
I have made a
giving over,
statement.
handing over charge.
Page 26 it makes it very clear, my lord. I have not given our charge.
Prima facie, I have satisfied this honorable court from the.
Page 26, fourth line.
Even the manual speaks the
As
same.
on
my
that,
lord.
the petitioner has not handed over the charge.
Manual speaks about the same,
Page 26,
same procedure, my lord.
Let them file an
Prima facie
file a reply. Matter will
from
be
the-
decided, finished off
That is the procedure.
on the reopening.
Lordship will see the manual also, my lord.
Your lordship
8.6.9
can
for a
decide the entire matter.
8.6.9, my lord. I would have placed everything, my lord. I thought that, my lord,
No.
the honorable court is satisfied from my explanation. I was prepared to at least to place the rule.
You argue it next week, Monday, Tuesday, whenever, Friday.
Then on that day, it may be considered, my lord. Status quo or whatever lordship wants to
Already
give.
your
All right,
document
we'll say
dictated.
status quo till the next date, whatever it may be. We
I
don't
have
know,
not
you get
given
your
an
instructions.
charge.
No, it's not about handing over charge, my lord. He cannot just stay there.
We don't know.
That will be another cause of, my lord, again.
It's not a single notice, my lord. Prima facie case I have made out, my lord.
We are not even connecting this writ petition to the other writ petition.
No, that's a different issue. Because now that has become infructuous because, my lord, it has been enhanced in this particular, my lord, order.
Whatever, but some order has to be passed in that also when the court has already issued notice.
My lord,
Obliged.
if that be so, my lord, he has himself preferred an appeal, my lord.
You see,
I understand, my lord.
when the matter is before the court,
Lordship.
when the court is in scene of the matter, then you cannot make the action has made the earlier writ petition infructuous after notices are being issued in the presence of counsels. And we presume that you have informed your department also. Then
That,
this is
otherwise, without there
overreaching.
being
We are refraining from making these statements, but this is overreaching.
my lord, if there is no such order of stay,
We can.
in that case, my lord, every writ petition automatically everything will be stayed, my lord.
No. That's not the issue. Mr. Counsel, you have to understand when the matter has been, it is not an ex parte order. We had issued notice.
No, even
It was
then, my lord,
incumbent,
if
it
there-
was incumbent on the council to make a mention and say that this matter has become infructuous, this is the order. Or we are in the process of issuing the order.
My lord, on the day when the notice is issued, probably the file was moved there, my lord. How can, my lord, they be, my lord, aware of this particular proceeding, my
No,
lord?
it's not
Earlier
about
proceeding.
day. We are asking you as a council, whether you must have informed your
I was not
clients.
appearing, my lord.
I don't know who appeared, but you will represent you and all your colleagues,
Yes.
representing the health department.
Deeply obliged. Deeply obliged.
Okay.
You want it next week? When do you want
Any
it?
day, my lord. Just 2 or 3 days will be enough, my lord, on this particular point, because this is a, my lord, interpretation, my lord, of this particular provision of section 23. Otherwise, there is nothing, my lord. That's why I was, my lord, expecting that at least some time will be given to us to consider on the interim.
Yesterday also he
Status
stopped-
quo, whatever, this will
Thursday only I
ultimately
start
affect
the
the order.
copy. Yesterday also he made the same clear.
All right, we'll have it on reopening.
No, let it be next
Because
week,
the,
my lord, on
because the
Monday.
other matter is
Monday.
also on 15.
Monday, my lord.
Monday.
Let it be on Monday.
22nd.
I will come up with the records, my lord.
My lord, your lordship has already passed on interim orders in collected with petitions, my lord, pertaining to the APSC express discharge orders.
Where is your order?
My lord, I'm placing a similar order, I'm paying for the same order, my lord. The impugned discharge order is at page 163.
No, where is the order of discharge?
Yes, page 163, my lord.
163.
Pertains to 2016 ACS batch, my lord. And regarding 2015 ACS batch, lordship has already passed an order on 8/9. Just now I've given that order. They're relying on para 141(2), but we say that we are covered by 141(1).
You are for civil service.
Civil service 2016 batch. Lordship, kindly peruse the earlier order, just now I've given. These were in respect of civil service 15 batch. Everything is same, only earlier discharge order is different. Everything is same. In para 2, lordship has recorded the earlier discharge order as 7/9/2018. Here it will be 2/1/2019. 2/1/2019. Rest everything is same.
All right. Notice. Same order.
Look, for all the respondents.
You are appearing for all
I'm
the
appearing.
respondents. Yes.
All of them.
59.
And my lord, the impugned discharge date is here 21/7/2025. In the order, it is recorded as 26/2025. I'll give the dates.
You give the dates.
Yes.
Yes.
Deeply.
In this case, similarly situated person approached before this honorable court lordship. That is page 64 lordship. Start from page 65. There are two an advertisement when published for inviting application for Junior Legislative Council and Under Secretary of Government of Assam Legislative Assembly, Assam Legal Assistant or Legal Member Under Secretary of Government of Assam.
We passed an order today?
Yes, today morning.
Huh? What is the item number?
59. Agot.
What is the item number?
WBC 533.
You are appearing for all the matters.
No, lordship. I don't know, lordship.
No. There were 3 posts advertised.
Lordship.
You had applied for all the 3.
All the 3 posts.
Item 11, lordship.
Huh?
Item 11.
11. Item 11, does order issue? Side over. Yes.
Lordship. What first I don't know at that time.
No, we only issued notice because the dates are already gone.
Lordship.
9, 10, 11 were the interview dates.
Lordship.
So you have filed the petition much later.
Later, lordship, because at that time I have no knowledge regarding.
So only notice.
Lordship. 15/10 lordship.
The same date, huh? It will come on the same date, whatever date is fixed. 17, na? 17.
Timing item 15.
May I please, your lordship? Lordship, petitioner have been dismissed from service on 19th of
Appeal also dismissed.
2024.
Appeal also dismissed.
Yes, appeal also
Third term
dismissed.
for the parties issue rule. Returnable 4 weeks. MSS Borua represents all
No, Lordship, 1 to 7.
to 7.
8 and 9, my line.
Mr. J.K. Goswami appears for 8 and 9. Since the respondent, the representative notices are waived, extra copies be furnished within 1 week from today. Respondents may complete their pleadings and file necessary affidavit. Yes.
Obliged.
Daily list for order item 34.
Maybe the order, as for last order 22/8/2025, the respondents will, they should have filed an affidavit regarding consequential report and inquiry report.
Activity before your lordship, but one problem I'm facing is lordship, all the respondents here, lordship 1 to 4, they're already retired from service, lordship. This one problem is there. So let my friend complete the new incumbents, lordship.
You are challenging with filing this contempt petition for non-compliance of which order?
Order paragraph 20.
Paragraph 20 of the
Page 28.
Page 28.
Yes, lordship.
Page 20, paragraph 28.
And lordship, it is complied, lord. My friend is at liberty to challenge the inquiry report, lordship.
Inquiry has been completed.
Lordship.
Then why are you filing it?
No, my lord. My responsibilities are in compliance as per the paragraph 20, my lord. There is a mandatory period, time period is given within 3 months from the date of judgment, they will have to complete the inquiry. But they have completed inquiry, my lord, as an expertise after about 1 year, 1 month.
All right.
There is a clear violation of the
But the inquiry is completed.
According to them, inquiry has been done. But actually in compliance with this judgment, my lord, a second opportunity was given to them because my date of birth was corrected at the initial stage, my lord.
As on date, whether the inquiry has been completed or not.
As on date, according to them, inquiry is completed as an expertise actually.
You have not received a copy.
Opportunity should be given.
Have you received a copy of the inquiry?
Yes, my lord. I have no. I had not received any inquiry report, but I had received a letter that I should have appeared on 12/10/2023.
Where is the copy?
Lordship, before lordship making the inquiry, lordship, he was called to participate in the inquiry process, lordship. He did not appear. Thereafter, lordship, I have given him an inquiry report, lordship. I have already served to him.
Why have you not brought it on record? The inquiry report has been completed. You should have brought it on record.
Lordship, I will, lordship. But lordship, only thing is, lordship, the incumbents, new incumbents have already come, lordship. This is the
new incumbents are there, but does it stop from issuing contempt, drawing up contempt against the incumbents who were retired because the direction was passed when they were in office? What were they doing for 1 year?
Lordship, the present incumbents were not there, lordship. Earlier incumbents were there, lordship.
Earlier incumbents.
Lordship.
But they were also there in the office at that time.
They are not in that capacity, lordship. The present incumbents, lordship, were not in the office, lordship.
At the time of filing contempt.
After passing of this order.
Yes, lordship.
When did these incumbents retire? These incumbents who you say...
The incumbents retired in the last part of 24, lordship.
24.
Lordship.
When was this order passed?
Lordship, order was passed in 22.
22.
Lordship.
So from 22 to 24, they were aware?
Yes, lordship. That is why the inquiry report is there, lordship.
So why has it not been brought in the record?
Lordship, the matter was not listed, Lordship, I'm sorry.
This is hardly an excuse.
Lordship,
Once the inquiry is done, you should have brought it on record to say that the order has been complied with.
Lordship, I'll find my affidavit, Lord. Short affidavit.
You're playing hide and seek.
No, not.
You're playing hide and seek. You say inquiry is completed and you're holding on to the inquiry report. You're not furnishing to the. You should
Lordship, I have furnished him, Lordship.
You should have brought it on record.
Lordship, I'll, Lordship.
You should have brought it. When was the inquiry concluded?
Inquiry is done on Lordship on 3/11/23, Lordship.
3/11/23.
Lordship.
And from 23 to 24 till they superannuated, they did not think it proper to bring it on record. They should have brought it on record.
Lordship, in fact, Lordship, the matter was, contempt was not listed, Lordship. In the
What has listing, not listing got to do
Lordship,
with
Lordship,
filing an affidavit?
This is, Lordship, I can. Lordship, give me 1 week time, I'll find my affidavit.
Only on 25/6/2025, a copy of the inquiry report is submitted before this honorable court without furnishing any copy. And that's why honorable court has made a query whether you have submitted any consequential report. Then my lord, another 3 days have been taken by them. On
Have you now received the copy of the inquiry?
Copy of the inquiry only on 25/6/2025.
You have received it.
I have received.
All right.
And then on that particular day, my lord, the honorable court has made a query. Why you have not submitted the consequential report? Then they have taken 3 dates on 22/8/2025.
What consequential report is to be submitted?
Of the consequential report, honorable court has directed to submit consequential report.
That was
of
done,
the
Lordship.
inquiry.
The order was
And
passed.
order, they have submitted, my lord. A copy has been submitted before this honorable court. And
What?
there is a serious contradiction of the inquiry report and inquiry report. That was submitted on 30, consequential report is prepared on 31/7/2025. 31/7/2025. After directing them by this honorable court. It is an afterthought.
No, what is it that you are seeking from the court? You want to put all of these people in jail? What relief, what orders you want from the court?
My lord, in compliance with the judgment, paragraph 20.
Right.
If they have not done any inquiry within 3 months, then within 2 months from the date of judgment, they should release my entire pensionary benefits.
So these orders cannot be passed in the contempt proceedings. We can draw up contempt proceedings, and if we find them guilty, we can put them to civil prison.
No, my first submission before this honorable.
the contempt proceeding,
Whenever
isn't
there is
it?
a mandatory period, they have not done this. Then there is specific reason. Then it is a clear violation. They may be directed to appear personally, my lord. Why they have not done inquiry? They may be directed to appear personally, my lord. It is a very serious matter, my lord. Because for last 9 years, they have not received issued a provisional pension. As per our rule 20.
What is the status now?
Lordship,
A family how can survive, my
asked
lord?
the petitioner to come to the court with.
We have heard that. You have passed an inquiry report.
Yes.
Now what?
Their office order has been passed on
You have
31/7.
rejected their claims.
Lordship,
Have you rejected their claims?
Lordship, we have asked him to resubmit his pension proposal so that we can forward it to the accountant general.
This is the conclusion of the inquiry.
This is not the conclusion of the inquiry, Lordship. Conclusion of inquiry is that, Lordship, there will be a reduction of rupee, Lordship, 7,41,000 from its pensionary benefit, Lord. This is the.
That has not been furnished to the petitioners.
That is been furnished, Lordship.
How?
Lordship, copy has been given to the person, petitioner personally, Lordship. It is marked to him, Lordship. And one copy I have also given him.
My lord, as per this Supreme Court, Rafiq Masih's case, Supreme Court, Honorable Court has already set aside the reduction.
See, the direction was to conclude an inquiry within 3 months.
Yes, my lord.
That direction
is not complied with, my lord.
belated.
So he can challenge the inquiry report, Lordship.
But that is, they are now trying to deduct the amount from me. There is no negligence on my part. My service is utilized by them at the verge of the retirement. At the verge of, they have asked me to go
well challenge the inquiry report, Lordship.
and that's why Honorable Court has set aside this that order. And then second opportunity was given, but 3 months mandatory period is giving. Otherwise, within 2 months, they will have to release my, as per the date of birth, which was corrected at the initial appointment. But they are going to correct as per SLC certificate date.
Pain is lordship going to the merits of
And
the
they have also,
petition.
let me see, let me submit before this. My lord, it is a very serious matter that there is a Supreme Court decision, another decision. Actually, subsequently, they cannot correct any date of birth. Department also, whenever it is corrected at the initial date of my appointment. If your lordship allow me, I can submit by the case law. But even then, Honorable Court has given a second opportunity as per Section 8 of this subsidiary rules, that you can refix the date of birth, but you will have to complete it within a period of 3 months, mandatory period. Because already 28 years back, my date of birth was corrected. They remain silent on the basis of the affidavit. And that's why the Honorable Court, recently Honorable Guwahati High Court also passed another judgment. But even then, why they have not complied with within a period of 3 months, my lord? They have deprived me, no provision and pension has been given me for last 9 years. A great third employee amount, their only intention is, my lord, to deduct my 7 lakhs rupees, 8 lakhs rupees, which according to them, I have drawn as an excess amount. That is not wrong, completely wrong, my lord. There is no negligence on my part, my lord. Only 3 months left from my to get a retirement in 2017. And that's why they have done this. This is arbitrarily, quite arbitrarily they have done, quite intentionally they have done, my lord. 1 year, 1 month, and again another 1 year, 7 years.
Where does it say that if they fail to conduct within 3 months,
No.
within 2 months they are supposed to release? Where is the direction?
Yes, my lord.
Which part? Which part?
Where's the direction?
Paragraph 20, where is it?
Yes, madam. Yes, paragraph 20, page number 28, my lord.
Yes.
Last part, my lord.
Yes, please read.
It is provided further that in the event the state respondents take a decision that there would be no further inquiry, then they should process the matter of pension and other retirement benefits of the petitioner by taking the petitioner date of birth as 2/3/1957. That is initially that of corrected. And thereafter, upon finalization, disburse the entire dues to the petitioner within a period of 2 months from today.
So this is in the event they decide not to proceed for an inquiry.
Yes.
They proceeded.
Yes, my lord.
They proceeded.
No, they have not done within 3 months.
I do not know whether you have the same copy. My limited knowledge in English says that they are given the liberty to hold an inquiry. And if they don't hold an inquiry, then they'll consider the earlier date of birth and release within 2 months.
No, my lord, here said, but the same must be completed within a period of 3 months.
Yes.
Must be completed.
Correct.
Yes.
But where does it say if they fail to complete within 3 months, they have to release your
They should have released within 2 months.
That is your submission. The order doesn't say so. The order doesn't say so. You file, if you are aggrieved, you can file. Mr. Counsel, if you are aggrieved, you can file. You can challenge the inquiry report if you want.
Yes.
We are closing the present proceedings.
My lord, a very poor employee, now a grade 3 employee, now on 9 years, he has been deprived. No provision and
Contempt
pension. Now, at least,
contempt petition is
my lord,
only to
my
find
respectful
whether
submission.
disobedience.
My lord.
You as a petitioner, your locus is only to bring it to the notice.
My respectful submission.
So, Mr. Sharma, your petition, as a petitioner, it is your locus to bring it to the notice of the court. Thereafter, it is between the court and the respondent to decide whether we proceed against them or not. If we choose not to proceed, you may go in appeal.
It is up to the honorable court. Now
we find that it is no longer necessary to
that
keep
will
the
be another part.
petition
But
alive.
my lord, they are going to deduct my rupees, another 7 lakhs rupees from my again there are some contradictory statements.
You challenge that order. We are not precluding you from challenging that order. If
My lord, I may be allowed to submit rejoinder on the next day about this.
No, we are closing it.
Rejoinder affidavit.
No, we are closing it. We are closing the contempt petition.
No, at least, my lord, I may be allowed to submit.
We cannot pass any orders interpreting the order which has already been passed and disobedience of which you are assailing in the contempt petition. That order is there, whatever form it is there, it is there.
My lord, they have not complied, they have not filed, not
We have
any
heard you.
affidavit, through
We have heard
affidavit
you.
in the last order, they should have filed this inquiry report and the consequential report before this honorable court. At least, my lord, the matter may kindly be taken after puja vacation, then I will file, if necessary, I will.
See, you have not filed the affidavit.
No file, yes.
Why have you not filed the affidavit bringing the contempt, the inquiry
Yes, my
report?
lord. Nothing, I'll file. How the department is going on in this one is very sad thing, my lord, in our state of Assam, my lord.
Type of submission, Lordship.
Very sad thing, but it is a serious
Counsel
matter, but
for
very
the
serious.
parties, the matter stands deferred to be listed after 4 weeks.
Lordship.
Yes, my lord.
The respondents are directed to file their affidavit. They are directed to bring on record the inquiry proceedings which they have conducted, claim to have conducted against the writ petitioner
Yes, sir.
by way of an affidavit
Yes, my lord.
by the next date fixed, failing which the court will proceed to exercise its contempt jurisdiction against the erring respondents. List on 15th October.
My lord, in the meantime, I will also file rejoinder.
You do whatever.
Rejoinder, I will. Not good.
এইটো মই ষ্টেটমেণ্টত পঠাই দিম কি কৰে।
We've taken steps for service of notice upon the sole respondent, my lord, on 13/3/2025, my lord. Office note dated 29/7/2025 reflect that neither ID card nor answer notice has been received back.
So let it come after.
Now, my lord,
Huh.
I pray before your lordship, the lordship may direct the registry, my lord, to track the postal consignment sent to the respondent, sole respondent, so that they may make a note of that.
Okay, heard counsel for parties. For the petitioner by office note dated 29/7/25. The office note dated 29/7/25 reflects that AD card or answer nor answer notice has been received back. on the sole respondent, although steps were taken as far back as 17/3/25. Stop. Registry will place the matter before the Lozima court, and the Lozima court will pass necessary orders with regard to service of notice on the sole respondent. By referring to the postal receipt, what do you call it? Track records.
Yes.
Track consignment record.
Obliged.
Made clear. It is last order dated. That the RTPL was dismissed, Lordship. And Lord.
Doesn't say dismiss, it says some order was passed. What is
No,
the-
no, we have perused the, we have given the order, Lordship, in the dismissal order. The RTPL dismissed that day on 29.
256.
Yes.
Yes, yes.
256.
Yes. On the basis of that compliance was.
Readable dismissed.
Lordship.
So
So it is in process, Lordship. Matter may come up after the vacation. Will apprise the court.
Lordship, 2 years were waiting terminated, Lordship. Lordship.
what was the direction by the single judge?
The single judge direction has to reinstate within one month, Lordship. Within 3 weeks, Lordship. It is a
Heard Mr. D. Monto, learned counsel for the petitioner, and Mr. Bose, learned counsel representing the respondents. These contempt petitions, you are appearing in all.
No, I'm in 39.
Mr. Gautam in contempt case number
Contempt case of Lordship 212 of 2024.
212. And
I am for item 40, my lord.
contempt case number
Case number 227.
227. Who appears for 197
195 I am.
and 214?
I am.
D. Monto for 214 and 197, Mr. G. Gautam for 212. And your name?
UU Khan.
UU Khan for 227. These contempt petitions have been filed alleging willful disobedience of the common judgment and order dated 25/2/2025, disposing of the writ petitions filed by the contempt petitioners, whereby the writ petitions were allowed. The impugned orders of termination of the writ petitioners were set aside, and the respondents were directed to reinstate all the writ petitioners back in service within 3 weeks from today, from the date of the order.
Yes.
Subject to reinstatement, it was further ordered that the respondents to proceed afresh against the petitioners individually after complying with due process of law, including the adherence to the principles of natural justice. In which case, it will be open for the authorities to take further consequential action. It was cited on page 27. Stop. Since this order was not complied with, these contempt petitions have been filed. Benefit. Respondents in the meantime preferred an appeal against the judgment and order, which stood dismissed by order dated 2008/2025 in WA 256 of 2025. But under such circumstances, it is seen that the order dated so and so, judgment and order dated so and so, passed by the coordinate bench in WPC so and so, remains to be complied with. It is seen that the directions contained in the judgment and order dated so and so, passed in WPC so and so by the coordinate bench, have not been complied with by the respondents. Stop. Mr. Ghosh.
Lordship, it may come after the vacation. Will apprise the court. It is in process.
There's nothing to apprise. You have to comply.
Lordship.
or we take proceedings.
Lordship, on the last day, they stated they'll take instructions in this regard, Lordship. Probably the order of reinstatement.
The
Last date of vacation, Lordship, is possible, Lordship.
Hmm?
Last date of
26th,
vacation,
Your-
26.
26th, Your Lord.
That day will apply, Lordship, if the Lordship, some initiative has been taken, because order is 23, Lordship. Without paying, Lordship.
The matter be listed on 15th. Now, which date you want?
26th.
26.
26th is not possible. It's for motion day. These are orders matter.
Then 15, Lordship.
15th of October,
15 of,
by which date the respondents will apprise this court about as to whether the directions contained in the judgment and order dated so and so, passed in WPC so and so, has been complied with. In the event the same is found to have not been complied with, court may proceed to pass consequential orders in these contempt petitions. List on 15th.
obliged.
Just 40, all 42.
May it please worship.
Hmm.
In item 41, my lord.
Hmm?
In item 41, notice was issued upon respondent number 326. However, respondent in regard to respondent number 4, notice has been returned answered with remark accuracy not available, return to sender. Therefore, I have filed an IA to rectify the defecable error against name of respondent number 4.
Any objection
No, please.
in the IA number 2728. Third counsel for parties, the IA has been filed seeking leave of the court to correct the name of respondent 4. Stop in the accompanying writ petition, that is WPC 1867 of 2025. Name of the respondent 4 was arrayed as Dr. Hemanto Dotto instead of Hemanto Kumar Dotto. He's not a doctor.
It's doctor, but Kumar was there in the early.
Hemanto Doctor, my lord. Only Doctor Hemanto Doctor.
Hemanto,
Doctor,
not Kumar.
not Kumar.
Don't know. Your prayer is Dr. Hemanto Dotto.
My prayer is it should be Dr. Himando Dotto, not Dr. Himando Kumar Dotto, not Kumar. Page 4, my lord, page 4. Page 4 of my application.
In the earlier, in the earlier writ petition, respondent 4 was arrayed as Hemanto Kumar Dotto instead of Dr. Hemanto Dotto. Stop. Petitioner submits that as a consequence, the steps which were undertaken were returned unserved. The counsel for the petitioner submits that this error occurred inadvertently and she may be permitted to rectify the same in the course title of the accompanying writ petition. Where Mr. E.K. Dotto appears for
Respond number 7.
Union
No, my lord, institute, my lord.
LGBRIMH Institute, Tezpur. Mr. Gautam for
Also, I appear for respondent number 9 in the writ petition, Your Lordship, Solindra Kumar Devi.
appears for the private respondent number 9 in the writ petition 1867 of 25.
4975 of 24.
Huh?
49, item number 43. These are tag matters.
No, in this IA, are you appearing?
Lordship,
In the accompanying writ petition, are you appearing?
no.
All right. We are passing orders in this one.
Lordship.
Go to the number now. Considering the submissions made, is highest in the law. Petitioner, the petitioner is permitted to file amended course title reflecting the name of respondent 4 as Dr. Hemanto Dotto instead of Hemanto Kumar Dotto, as was earlier reflected in the course title. Stop. I accordingly stands allowed. Petitioner will file amended course title within 1 week from today. In the writ petition, you write in view of the order passed today, respondent number 4 is to be read as Dr. Hemanto Kumar, Dr. Hemanto Dotto instead of Hemanto Kumar Dotto. Petitioner will file amended course title within 1 week from today. Writ petition be listed thereafter. Let both these writ petitions be listed in the month of October on a date to be fixed by the registrar.
Supplementary release for order item 60.
May it please your lordship. I had mentioned this matters yesterday for correction. Lordship, in
Where is the correction?
item 60,
Oh.
the date of the order should be 10/9/25 and not 28/25. And second,
What date of order?
your lordship had passed this order on 10/9/25 and not on 28/25.
Oh, this order was passed on 10/9.
Yes, lordship. And secondly, lordship, in para 3 of the first petitioner, the date of joining should be 31/8/15, not 15/9/15, although he completed it on 15/9/17.
31,
8/15,
8/15.
para 3.
31, 8/15.
Yes, Lord. 4.44.
And 15/9/17 is not relevant.
Yes, no, 15/9/17 is relevant. That date he completed the probation, but he joined on 31/8/15.
Okay. But that is what we wrote.
Yes, Lord.
Okay. Joined his service on 13/9, on
31/8.
31/8/15. That's all in this matter.
Yes, Lord. That with
Art-
regard to Jyotindra Prasad.
Heard counsel for the writ petitioner.
Yeah.
While passing the order in the present writ petition, which was moved on which date?
10/9/25, Lord.
10/9/25. The date in the order came to be reflected as 2008/25 instead of 10/9/25. That apart, in para 3 of the order, it was recorded that the writ petitioner joined service on 15/9/2015 instead of 31/8/2015. So accordingly, the order dated 2008/25 is to be read as an order passed on 10/9/2025. And in para 3, the date of joining of the writ petitioner is to be read as 31/8/25, 2015 instead of 15/9/2015 as recorded earlier. These order passed today is to be read together with the order passed in the writ petition issuing the notice. That's all?
No.
Mr. J.K. Goswami appears for the respondent.
All the rest.
And the second matter, Lordship,
Huh.
again, the date should be the date of the order should be 10/9/25.
10/9/25.
And in para 3,
Hmm.
it's written in the third line, pursuant to his, she is a lady, her. Then fourth line, she joined in service. Then the date she complete, again, it should be fifth line, she joined in service.
These you can ignore. It doesn't affect the
Yes,
content of the judgment.
Lordship, then
Yeah.
her date of joining is 26/8/15. So she completed her 2 years probation on
Instead of 12/9, it should be
26/8/15,
26/8/15.
which accordingly she completed on 26/8/17. and
completed on
26/8/17.
26/8/17.
And again, Lordship, she was discharged for the first time on 12/2/19.
That's all?
There are 4, Lordship. The submission of the learned senior counsel appearing for our side. I've provided the copy.
Yes.
Having successfully completed her 2 years probation.
You are
on
reading from para 4.
Para 4, the learned senior counsel submits that in terms of the findings arrived at by the division bench, the petitioner, having successfully completed her 2 years probation period on 26/8/17, and there being no further extension of her probation period, the petitioner is squarely covered by the direction of the division bench rendered.
Where are you reading it from?
Lordship, I have given the fresh copy. That, Lordship, actually the submission of the senior counsel that has been recorded it didn't appear in the prior order passed by your Lordship.
It doesn't it doesn't have any reverse effect on the order.
Yes, Lord.
In the final direction of the order,
Lord.
it doesn't have any effect. Does it affect the interim orders that is passed?
No, Lord.
Then
And
this can be corrected or inserted later
yes,
at the time of hearing.
correction in the brief. Otherwise, it's all right.
No, because then we'll have to recall this order.
Yes, Lordship. I understand.
So we'll recall it and we'll pass, but then your interim order also goes.
Yes, Lordship. I understand.
It is up to you.
I understand. Nothing.
In this matter, you write again, the order. Matter was moved on 10/9/25. However, the date reflected in the order is 2008/25. Therefore, the date of the order should be read as 10/9/25 instead of 2008/25. That apart, in para 3, date of joining of the writ petitioner should be read as 26/8/2015 instead of 12/9/2015. And his period of completion should be read as 26/8/2017 instead of 12/9/2017. The disorder of the petitioner, typographical errors had crept in while this order was passed. Consequently, the same stands corrected by the order passed today. The interim order issued in the matter on 10/9/2025, therefore, is to be read together with this order passed today. That's all?
There are 2 others.
2 others.
Yes,
No, we wanted you to give a chart with all these.
Yes,
Was it provided correctly? We had said in respect of each of the writ petitioners, give us a chart. The date of joint of provisions, I don't know whether it was given?
It was given, Lordship.
I don't know.
My
There
friend
is
made a
some
mistake
confusion.
in the date of joining in. My friend made a mistake in the date of
see?
joining in.
Yes, here,
Pallavi Sharma Chaudhary, third matter. Again, the date should be 10/9/25.
right, 10/9. Okay.
Then para 3, Lordship. She joined in service not on 12/8/15, it was on 31/8/15.
Then,
And accordingly, her probation came to an end not on 12/8/17, but on 31/8/17.
discharge on
Discharged on 26/18 prior.
20/06.
Yes,
Okay, that's it. Same order. Ensure the corrections.
Not this,
Yes. This orders will be corrigendums issued.
And fourth matter,
63.
Date, same date. 10/9.
10/9/25.
Okay,
And
then
he joined in service on 31/8/15.
31/8/15
Yes, Lordship.
instead of 12/8.
Yes, Lordship.
No, sorry.
It should be 31/8/15.
31/8/15. Completion.
Completion on 31/8/17.
Yes, then
Discharged on 26/18.
this is all right. 26 is here.
26/18.
20.
Yes, Lord.
Here.
And then retapil number should be 159/2020.
2020.
Yes, Lord.
Okay,
That's all.
same order.
I'm grateful. Much obliged.
Daily rate for admission items 45 and 46.
These matters where the SLC and the DLC and the SLC both had recommended the names, then the matter was awaiting final appointment orders. Now time was being taken on the ground that SOP is being made published. That SOP has come about, that is on 30th of August.
SOP has come, then then notice has come.
Notice has
Did
also
you submit all these information?
Yes, we have submitted.
Then they'll take care. We pass some order.
Because
Disposing of these matters.
Yes, because earlier also Lordship has passed an order, whereby it was held that this notification of 27/9 is not applicable in these cases. That is there in this particular case itself. I don't know 46 matter.
No, here your recommendation was done by DLC, then by SLC.
Yes. Now it's awaiting the final the ministerial works, rather by the appointment orders, etc. to be passed. The recommendation was already complete,
Oh, where is the SOP?
Have a copy, This SOP is basically nothing but reiteration of the orders of this honorable court, just a kind of a compilation, nothing else, And with regard to our case, there is nothing there,
You have challenged the OM.
No, we did not challenge the OM because we say it's not applicable to us,
You have not assailed the OM.
No.
Then?
Well, our case is we are not covered by this OM because this OM was with regard to those whose cases were under consideration. But our case is that it was already considered. Only formalities of appointment orders were to be issued.
No, but you, what do you say about the executive order?
Executive order, it is only with regard to those cases how this is to be considered. These are covered by your lordship's orders of this honorable court.
Where is that order?
No, but that order, of course, in this particular case, your lordship passed an order, on 1/6/2000, 6/1/2025,
6/1.
2025, lordship passed an order.
6/1.
Yes, madam. In item 46, madam. WPC number 5293, madam. Page number 3, madam. Last but 4 paragraphs. It is to be noted. And then the finance department was granted 2 weeks time to my lord, issue necessary approval.
What happened after that?
After that, my lord, they've been taking time. Well, first, my lord, they're saying that the SOP is being, my lord, formulated, therefore, my lord, they wanted time. That's what, what is done.
Yes, respondent, what do you say?
Yes, as per our SOP, he have to file application before 15/9/25. And on the basis of this.
You have filed this application?
Yes, ma'am. I filed, my lord.
15/9.
15/9, my lord. Copy, I have the copy.
You have filed it online?
No, it was deposited, my lord, offline when.
In terms of the SOP?
Yes, ma'am.
Why?
Because, my lord, they were told to deposit, so they had deposited, my lord.
Any affidavits filed here?
Yes, we have filed our affidavit.
Well,
on
then the matter is to come up for
46.
hearing. We'll take it up for hearing. We'll have to hear this, whether the office memorandum is applicable to cases of your nature.
My lord, the office member has got nothing there, my lord.
It has to be heard and decided.
My lord.
You argue your case if you want to today.
My lord,
Your case is that it is prospective.
Yes, my lord.
Ah.
Number one,
When was the SLC?
Yes, my lord.
report?
My SLC, my lord, DLC on 30/12/2015 and the SLC, my lord, on 1/3/2024. 1/3/2024, first of March.
24.
And this notification came on 27/9. And all this,
This notification came on 18/9.
I'm sorry.
OM?
Sorry, 89.
89.
Right.
18/9.
89. Sorry, 89.
So their cases are prior to that OM.
Yes.
Why was it kept pending?
For approval from Finance Department, as per our affidavit, kindly come to page 41.
In which writ petition? 5291?
5293.
93. Oh. Page
Yes.
number?
41.
41.
41.
Oh.
The department is regularly pursuing with the judicial department for their early views on the matter via letter so and so dated 10/3/25 and subsequent reminder letter so and so dated 1/4/25. Views of judicial department is awaited till date. And on
Right, but
yes, after that, for that SOP, I think it was affidavit has already filed on.
no, the moot question here is whether the OM dated 18/9/24 is applicable to these cases. Because till 18/9,
Yes, Lordship.
it was this 2015 OM, I think.
Yes.
2015.
Yes.
So as per 2015, you are required to consider the cases.
These cases were already considered by the SLC. Lordship.
And recommended, but why he is looking for
Yes.
an appointment?
Yes.
So why the appointment was not issued in terms of the recommendation? That is the question to be answered by the department.
Yes.
Yes, finance, everything.
Our step 10, my lord, is clear, my lord, because they had sought for an approval because SLC has admittedly, my lord, on 1st of March 2024, my lord, they have given the approval. Now thereafter, my lord, the concurrence of the finance department was required, my lord, for finally placing that person on job, my lord. Now at that stage, my lord, this OM has come in the month of September. And therefore, my lord, there was a hold, my lord, put on hold by the, my lord, personnel department. Because it is the personnel department who is the nodal agency for all professional appointments. The role of finance department comes at the last stage, my lord. Now, under that stage, my lord, it was sent to the finance, but then again it was, my lord, called back from the finance department. It was called back, and now the matter is with, my lord, the personnel department and the administrative department concerned, on which, my lord, the deceased person has worked. I mean, the petition on where, my lord, the deceased person has worked. Petitioner's father, my lord, the predecessor in interest. So, my lord, the proposals from that administrative department and personnel department are yet to be received by the finance department for appraisal.
That is a different issue, but you can't say that 18.9 will be a bar.
18.9, but what I find, my lord, 18.9 notification, if lordship is having it, my lord. Yes, my lord.
Is it here?
Yes.
Page number?
18.9.
33. Move to 90. Deputation number 352 now, right? Page number 33.
Who has filed the petition? The writ petitioners are different.
Different. Two different departments also. I am for the Food and Public Distribution Department.
Page number, which page number?
33.
33, yes.
33, if lordship precisely come to, my lord, page number 34, the last paragraph. In view of the circumstances mentioned above, it has been decided that no cases for appointment on compassionate grounds to the family member of state government employees who died in harness or retired prematurely on being declared permanently incapacitated for service or missing, or whose whereabouts is not known prior to 31/3/2017 shall be entertained by any administrative department authority so and so for any reason whatsoever, nor be placed before SLC DLC for recommendation of candidates for appointment on compassionate ground. So the date is, my lord, 31/3/2017. The cases of employees who died in harness after 31/3/2017 have been taken care of by way of compassionate family pension scheme in lieu of compassionate appointment. So in order to, my lord, prevent giving double benefit, my lord, perhaps this office memorandum is trying to take care of the situation. Now here is a case where, my lord, in case of, my lord, that Nandita Das writ petition, he died, my lord, 5/2/2015. 5/2/2015. And in case of Montu Bayan, my lord, the predecessor in interest of the petitioner, he died in, my lord, 2006. Far long ago. In between, my lord, Debabrata Tewari has come. Now, this office memorandum also discusses the implications and consequences arising out of the decision in Debabrata Tewari that lordship will find in the preceding page, my lord, of that OM. The last but two paragraphs, my lord, at page 33. So now, therefore, my lord, since the law relating to compassionate appointment.
No. These decisions you have taken.
My lord.
Ultimately on 18.9. These are
18.
effective from 18.9.
18.9, yes.
Now, earlier recommendations, you have to take a call what to do.
Absolutely. So therefore, my lord, in these two cases also, my lord, it is pending before the personnel department. So far as my department's instruction goes, my lord, because at
the personnel?
At one point of time, the files were moved to the finance department for giving concurrence, plainly and simply, because SLC had, my lord, approved it. So we have no other option but to grant approval. And they were about to be appointed. At that stage, my lord, these things has come. Now the file has again been retrieved, my lord, back to the personnel department. Some views of the judicial department, whom I am not representing, of course, my lord, has also been sought for by the personnel department. Now this lordship will only take one aspect of the matter, my lord, with all sincerity, my lord. This OM and SOP all are being circulated by the personnel department. So that is the nodal agency, nodal department.
Who is representing personnel? You are representing.
Because the decision
So you have to take a call. What is to be done to all these cases where the approvals were granted earlier? When did your father expire?
My lord, 5/2/15.
5 to 15.
Yes.
When was the approval of the SLC?
DLC was given into 30/12/2015, therefore it was kept pending. And SLC came on 1/3/24.
SLC is in 1/3/24.
After DLC approval, did you come before this court?
No, my lord, no, my lord.
You did not?
No.
2015 to 2024, almost 9 years.
No,
What are
because,
you doing?
because there were correspondences. I would show there were
No, but what
correspondences.
how are you surviving?
No, surviving, my lord, surviving is not, my lord, taking, my lord, breath when living, being alive, my lord. Surviving, my lord, we have survived
See,
somehow.
compassion is
True, man,
compassion is to be
Understand, man.
conferred,
My lord.
understanding the immediacy, the
True.
urgency.
True, true.
That has 1 year, 2 year, one can understand. But 8, 9 years,
But somehow we have survived, my lord. And that's, my lord, after these recommendations, my lord, the irony is, my lord, they take time, my lord, on this and that plea, my lord. And then, my lord, they say that we are
this is not
out of the court.
This is not the issue, Mr. Doctor. First thing is, it's not a matter of right.
Absolutely, my lord, absolutely.
Not a matter of right. Secondly, these are some of the provisions offered by welfare state for accommodation. Therefore, you need to, some benefits are conferred, so your cases can also be considered.
My
Now, today, if you have to urge the case that 18/9/24 is not binding on you, etc., you'll have to perhaps address on your, crystallize on your rights. What is your rights?
My lord, so far the rights are concerned, my lord, first of all, my lord, this OM.
Therefore, it will require some hearing. We will keep it after the reopening.
My lord,
Pleadings have been exchanged.
my lord.
They have filed
Pleadings
their
are exchanged. The respondents are at liberty to file additional pleadings if the need so arises. The matters will be taken up for hearing and disposal at the admission stage. List in the first week of November.
I'm so obliged.
Obliged.
47.
What's a PPO and GPO has been issued by the Office of the Accountant General on.
Show to him, show to him.
I have.
You have received?
Yes, let the matter come up next week, Lordship. I'll get the instruction from the petitioner.
Next week, why? Let it come up. On Friday, we can.
Yes.
Friday.
Yes, Lordship.
Let the matter be listed on Friday on the request made by the counsel for the petitioner, as it is submitted by the learned counsel representing the Accountant General, that the PPO and
GPO.
GPF have been released. PPO and GPO
Pension payment order and gratuity payment order
have been released in favor of the writ petitioner by the Accountant General Office. Mr. Upadhyay appears for the respondent.
Irrigation Department.
Irrigation Department, list on Friday.
Yes, obliged, Lordship.
48.
May I please, Lordship? Instruction received, Lordship. 4 weeks time to file it. In a position.
State Counsel, Mr. E. Chakraborty submits that instructions have been received and he'd like to file an affidavit within 4 weeks. Prayer made is not objected to by the counsel for petitioner, list accordingly after 4 weeks.
Obliged, Lordship.
My lord, date may be given, my lord. Date, my lord.
Let him file first.
Obliged.
This is only as well. Oh my God. Yes.
Notice was issued on the last occasion, Lordship.
Extra copy not served, Lordship.
Not served.
Maybe some inadvertence will serve it, Lordship.
Counsel for the petitioner undertakes to serve extra copies of the writ petition on the respondent counsel within 1 week.
Yes.
MS S. Borua appears for the state. Mr. J. Handick appears for the revenue department.
Obliged. My lord, in this case, I have received affidavit just now. Received affidavit just
Today we have filed for.
file rejoinder.
Counsel for the State Council, MSS Burwa submits that affidavit has been filed today during the course of the day. Counsel for the petitioner, Mr. K. Kolera,
We have filed already, Lord.
submits that you'd like to file rejoinder to the affidavit. He prays for 3 weeks' time. List after 3 weeks.
Plus.
Nice.
51.
Please, your mind. This matter, your lordship, basically, the respondents have filed their affidavit. We have also filed the reply. And your lordship, it may be hard because of this matters on a hearing day because it will take some time. That's why. The hearing day next week, now, I don't know how about the time they go to.
28th
Of
October. Readings have been exchanged. Parties submit that, counsel for the parties submit that the matter be listed for admission hearing. List on 28th of November, October.
Obliged. Obliged.
62.
We have received our signed affidavit. I'm seeking 2 days accommodation. I'll file it by tomorrow.
Yes.
Fix a date, Mala. In the meantime, I will file my response if required.
Mr. M. Dotto for the petitioner, Mr. Rai Bothakur for the respondents. Mr. Bothakur submits that the affidavit will be filed within the course of this week. Mr. Dotto submits that the matter be listed for admission in the month of October. 27th October. The petitioners may file rejoinder affidavit to the affidavit proposed to be filed with the state. In the meantime,
There is an interim.
the interim order passed earlier will continue until further orders.
Yeah, 3.
The peruse the last order, my lord, 27th, 8th, my lord. It's on our
Accountant, what is this?
Yes, what happened, my lord? Husband was given the pension, but the husband only inserted the name of his son. Then it has been sent back to the authorities. I think one inquiry is required to be made, and further the treasury officer has been directed to surrender, get the two halves of PPO. So that may take some time. We'll do it at the earliest.
Nominee is the son.
Son. Yes.
So you have released the pension.
That pension.
Family
yes,
pension.
No, family pension has not been released. Family
So
pension in
under
her name
the-
has not. She is
under
claiming
the-
family.
She's the widow.
Widow man. She is claiming family pension. Her name was not inserted in the PP.
Under the rules, it is the widow.
We'll do that, my lord, but we have your lordship that later we'll.
problem is, my lord, the name of the petitioner has not reflected in the PPO, my lord.
That is the problem.
So who will make the corrections?
Well, once we get the clarification as sought for by these letters, my lord, and the parts from
Clarification from whom?
From my lord, Additional Deputy Commissioner Personnel, Nagaon. Second,
to what effect?
To the effect that as to why her name was not inserted. And secondly,
How will they give you clarification?
I understand. And secondly, my lord, another thing.
Name was inserted by the government servant.
Or
Late
the
government servant.
housefile employee.
How
Now,
will
secondly,
they-
my lord, the treasury office is required to give us the second half of the PPO. So it has also been, he has also been informed. She has also been requested to surrender her part of PPO, and then it will.
Who has been requested?
Petitioner, my lord. There's a third letter, my lord. 4720.
Petitioner has a PPO.
My lord, petitioner is the widow, my lord.
So you have got a PPO.
No, my lord. Earlier, my lord, the pension was sanctioned in favor of the deceased husband, my lord.
That part is available with you.
PPO,
One
my
part
lord,
of
my
the-
name has not been reflected, my lord.
We know,
My lord.
but whether that part, pensioners part, is it available with you?
No, my lord.
Then
Actually, we have requested a letter come, then we'll, because we need that.
how will the name be corrected unless, who has the, there are three parts. Who has the other parts?
Other parts, my lord, in the my lord, custody of the treasury officer.
One is in the-
Treasury office will be there.
My lord.
One in the treasury office, one in the administrative office.
My lord.
One with the pensioner.
My lord, I am the widow, my lord. After that, I have no, my lord. That part, my lord.
Is the son the party here?
No, he is not a party.
Not party, my lord.
Then make him a party. He is the person whose name is there. It must have been with him.
Then, my lord, I have to receive instruction, my lord.
Please get.
My lord. Immediately after vacation, my lord. Whether, my lord, that part available.
Mr. K.R. Pamgiri appears for the petitioner, Mr. D. Bhattacharya for the Accountant General, Mr. J.K. Goswami for Respondent 5 also. Respondent 5, the Deputy Commissioner. And Mr. J. Andik for the Revenue Department. The Council for the Accountant General submits that in the event the pensioners portion of the PPO, a pensioners portion as well as the treasury officers portion is returned back to the. No, then you'll need all the three parts.
I'll need the three parts. my lord. So let him get the instruction, what is
The Accountant General's Council submits that for correction and incorporation of the name of the writ petitioner in the PPO, the PPO in all its parts will have to be handed over to the Accountant General's office. And to that extent, communications have been addressed to the office of the Deputy Commissioner.
Deputy, no, man.
Treasury office.
Huh?
Two letters have been addressed, my lord.
One to Deputy Commissioner.
One to Additional Deputy Commissioner,
Additional
Personnel,
Deputy
Nagaon,
Commissioner Nagaon
and Treasury
the
Officer.
Treasury Officer Nagaon. Stop. The third part, which is required to be, which is available with the pensioner, should also be returned back if available with the writ petitioner. Stop. Counsel for the petitioner submits that you'd like to complete his instructions on this regard. Accordingly, matter stands deferred to be listed after 4 weeks.
Obliged.
54.
After vacation? No,
Vacation.
after vacation.
My lord, some anonymous complaint was received, which the petitioner was directed to inquire. As an inquiry,
That we've heard.
yes,
We are asking for some, we had asked for some records.
yes. Last occasion, Mr. Dinath submitted that he has received the record and he would like to go.
Where is Mr. Nath?
Lordship, he is on lake, Lordship, court number? Court number? One, court number 1.
If you are agreeable, then we'll have it after vacations immediately. In terms of the earlier order, the relevant records have been received by the learned senior government advocate. In view of the fact that the matter will require some hearing, counsel for the parties are agreeable that the matter should be listed for hearing immediately after reopening on 16th
Yes.
October,
Yes,
16th.
deeply obliged, sir.
55.
My lord, the money suit has been withdrawn, my lord. Money suit was there, my lord. Tractor suit was withdrawn earlier, my lord. Money suit has been withdrawn. And complaint case had nothing to do with this, my lord, to the base of the matter. Because that is during the pendency of the tenancy agreement, my lord. The rent is to be deposited in the account of the NRB Associates, which is the loan account. But they formed a company, NRB Associates Private Limited, and some fund has been diverted. Nothing to the basic thing, my lord, as enunciated by this 21 judgment, para 35.
Which judgment?
That my reference shown, my lord.
Lordship, in view of the recent judgment, Lordship, we are not objecting.
ISOMI.
No, Lordship,
which
in the,
judgment?
it is a managing director, Bihar State Food Civil Supply Corporation.
Yes,
Mr.
that is
Sanjay
also
Kumar.
there.
Recent 25 judgment.
Ah.
So here, Lordship, all the issues can be decided by the tribunal. Lord.
Which judgment? Where is the judgment?
There it is.
My lord, this is the latest, my lord, I couldn't find it
Acknowledge.
out. Yes. As per this, my lord, the appendix. 35, para 35. Let me come. It does not go to the root of the matter, my lord. Yeah. Partnership agreement. There are two basic things, my lord.
Para 21 onwards, Lordship, finding further. Reference I had it all only had to be
Your allegation are in regard to what?
Only, my lord, some diversion of fund, my lord, nothing more than that. Because tenant was directed to deposit in his account of the company. Nothing more than
What
that.
do you say?
He's not opposing that.
in view of this judgment, Lordship, that
No,
all
there
issue.
is no allegation that any agreement was
No.
Executed fraudulently or anything like that.
Nothing.
They have alleged that we have fraudulently executed the rent agreement.
No, no, no.
And-
The agreement where the arbitration agreement.
No.
No.
That initial agreement you don't dispute.
No, don't dispute.
Then we'll close it in terms of this.
Instead of all the questions, we may give liberty to raise all the questions before
Ah,
arbitral
before the arbitral tribunal.
Yes, Lord.
Heard. Learned counsel for the parties. This application has been filed under section 11(6) of the Arbitration and Conciliation Act 1996. With a prayer for the direction to appoint an arbitrator by the court to decide and arbitrate on the disputes arising by and between the parties in terms of where is the agreement?
Agreement. Yes.
Well, the arbitration clause is at page 30.
30.
30. It starts at page 25, but paragraph 17.
In respect of the disputes arising by and between the parties pursuant to the deed of partnership executed between the parties, namely the petitioner
and the respondent
as the second party and the respondent as the first party. So this deed was executed on 11th day of January 2020 for undertaking the business by way of partnership and dealing in the items mentioned at clause 1 of the said agreement. Stop. Clause 17 of the said agreement provides for resolution of disputes by way of arbitration. During the course of the business between the parties, certain disputes arose between the parties, and certain allegations of certain allegations were made by the petitioner against the respondent, and complaints, criminal complaints have been filed before the appropriate authorities. Stop that apart. Money suit was also filed. Title suit and money suit was also filed before the competent court of civil jurisdiction by the petitioner. Stop. Subsequently, in view of the arbitration clause being available in the agreement, the civil court declined to interfere with the
withdrawals.
We have withdrawn.
They have himself
okay. Subsequently, both the money suit and the title suit stood withdrawn in view of the arbitration clause available in the agreement. Stop. The petitioner, in view of the disputes, in view of the disputes stated to have arisen between the petitioner and the respondent, issued a notice under section 21, which is at page
71.
Notice dated
28/10/24.
71.
71.
No.
Oh, I'm sorry, my lord. That is earlier notice, my lord, page 109. I'm sorry. 109.
Dated 28/1/2025.
25.
Calling upon the respondent to appoint an arbitrator. Did you name an arbitrator there?
Hello,
They have
yes.
Calling upon to concur on nominating
Yeah, we
the
have
name
given the name of person
mentioned
Deka.
in the arbitrator in the notice. Stop. The respondents, did you reply to the,
no, we have not received because since January till April, the petitioners is out of Tinsukia, Dibrugarh, they're in Guwahati. They have not received the notices.
then
His address was Dibrugarh, and we have delivered that page 118. The delivery is there.
right? However, the respondent disputes the contention of the petitioner that the notice was issued on the ground that the same has not been received
But he does not say about that delivered address.
by the respondent. Stop. The counsel for the petitioner on the other end submits that the same has been sent by post at his registered address, at his address available on the records, and the same has been delivered as per the postal receipt received from the postal department.
Yes.
Stop. The counsel for the respondent, however, submits that the notice had never been received. Stop. Better. Now, what is your submission?
Regarding appointment lawsuit. MK Bhattacharya lawsuit.
Since there was no reply received from the respondents, the petitioner has filed the application under section 11(6) of the Arbitration and Conciliation Act, where having heard the counsel for the parties, it is seen that although the notice under section 21 is stated to have been issued at the proper address of the respondent, counsel for respondent on instruction maintains that the said notice has not been issued. Stop.
Since he was out of station, my lord, please.
as he was out of station.
Out of station.
Stop.
And-
Therefore, although a submission was initially made that the stage for appointment of an arbitrator under section 11(6) has not yet arrived, as the petitioner never received the notice under section 21, and therefore there was no refusal by the respondent to appoint the arbitrator mentioned in the said notice. Stop. However, the counsel for the petitioner on instructions fairly submits that now that the matter is before the court, they have no difficulty in accepting the nomination as may be ordered by the court. Stop. Under such circumstances,
In another lordship, we have alleged the fraud that is preliminary.
the
Since the
councils,
petitioner.
the respective councils have pressed into service the judgments in support of their contentions. The respondent councils have pressed into the judgments of the apex court in support of its contentions that when allegations of fraud or forgery is made and which goes to the root of the matter, these disputes which may have arisen cannot be resolved by way of arbitration. So be that as it may, in view of the recent judgment passed by the apex court in so-and-so versus so-and-so, the apex court has elaborately dealt with the matter and have laid down the guidelines under which ordinarily matters may be referred to arbitration,
When the
subject to the exceptions mentioned in these guidelines. Stop. The said judgment and its relevant paragraphs are extracted below. But having considered the submissions and the judgments cited at the bar, it is seen that although the allegations of fraud or other criminal intent has been alleged into the matter, there is no dispute by the respondents that the partnership agreement dated so-and-so was executed by and between the parties, or that certain disputes had arisen by and between the parties during the course of their business. And stop. Therefore, in terms of clause 17 of the said partnership deed, any dispute that may have arisen should be and may be referred for arbitration. Stop. Under such circumstances, considering the fact that although a notice under section 21 has been issued, but the same has been stated to be not received by the respondents as he was stated to be out of station, relegating the petitioner to issue a fresh notice or directing the respondent to submit a reply will further delay the matter, which the parties have otherwise agreed to resolve their dispute by reference to arbitration. Stop. Under such circumstances, this court, under the powers conferred under section 11(6), consider it appropriate to refer this matter to arbitration. Stop.
Sharani Goswami.
MK Bhattacharya, you will better learn.
What are you doing?
How about Mr. S.K. Sharma? Sushil Kumar Sharma? Any objections?
MK Bhattacharya, you will be better learn.
That is my
Huh?
Sushil Kumar Sharma.
No, you have to agree on a name, otherwise we'll
MK Bhattacharya, lordship, he has taken now lots of arbitration.
No,
matter.
most arbitrations will be a handicap for the arbitrator. How many
Yes.
arbitrations will they take? What about the name suggested by the counsel for the petitioner?
Yes, he has less.
Then Sharma, SK.
S.K. Sharma. Or
Chayani Gusami, anyway.
Chayarani Goswami. Yes,
SK Sharma.
you have to agree on a name.
Oh.
This court considers it appropriate to appoint, all right, we'll appoint Mr. Pradeep Kumar Das, who is somewhere in between.
Yes.
Pradeep Kumar Das, retired
Das.
district and session judge, Assam, to be the arbitrator in these matters to resolve the disputes arising by and between the parties. This appointment, however, is subject to the written declaration that is required to be furnished under section 12(1) of the Arbitration and Conciliation Act. The parties may appear before the prospective arbitrator and communicate a copy of this order. Can you do it by
November.
Saturday?
If we get the copy, my lord, it can be done.
We'll get the copy. Then we'll.
It's in the next week, my lord.
No. We will keep it on. You appear before the arbitrator on 20. September.
Yes. My lord.
And
My lord, it may be 22nd, my lord.
22nd.
22nd or 23rd.
22nd.
Before the arbitrator.
Yes.
All right. 22nd.
Yes.
22nd. And
Just to Lulam.
because we thought we will close this, confirm the appointment.
Yes, my lord. Before that, it can be done.
No, if you choose 22nd, it may not be
My lord,
possible.
the losses may fix it, my lord, 25th, my lord. We can.
No. After you communicate, they'll have to give a confirmation in writing.
Yeah.
So therefore, we thought 20, so that you can appear and get a confirmation, and we'll have the matter listed on 23rd, and we can close the matter.
Yes.
We'll communicate it on 20. Appear before the arbitrator along with a copy of this order on 20/09. Stop. Whereupon the arbitrator may consider issuing the written declaration under section 12, and if the same is issued, the order of confirmation can be passed. List on 23rd September.
Address is here, my lord.
Address, you'll have to get it from the registry.
Registry I shall get.
Yet nothing. Oh, I am informed he is a permanent resident of Bongaigaon.
Yes, Lordship, he is outside, Lordship. Therefore, MK Bhattacharya will.
All right, Srimati Chayarani Goswami.
What?
Chayarani Goswami. We had been appointing Mr. Bhattacharya in the last 2-3 arbitrations, so we thought he may be overburdened. A judgment to judgment. Tick mark for different. Into silent. Date se leke thaki so. This must come out today. Upload.
May I please the lordship?
Yes.
My lord, on the last occasion, your lordship was pleased to ask for to bring the judgment, my lord. The subject matter is the case is that, my lord, the petitioner was placed under suspension on 18/1/25 at page 37.
Yes.
And thereafter, my lord, was issued on 10/3/25 at page 38. At page 38, there was a shock was issued by the authority. Now, my lord, and I have filed my additional affidavit that your lordship will see at page 77. The extension of the suspension. Lordship kindly turn to page 77, which is part of the additional affidavit. Last two paragraphs, my lord. May I read, my lord? This is basically extension of the suspension, my lord. And
77.
yes, my lord.
Yes.
Last two paragraph, my lord, and whereas the Guwahati Municipal Corporation Authority issued us was proceed to the further departmental proceeding has already been initiated against Khagen Chandra Das, Superintendent IC under suspension is considering gravity of the charges allegation against the Khagen Chandra Das so and so is undersigned deemed necessary to extend the period of suspension until further order, my lord. Only that was, my lord, that was not been reasonable. Then, my lord, a coordinate bench judgment came out, my lord, that your lordship will see operative part of the very affidavit at page 95, my lord. Operative part, para 29. The law laid down by the Honorable Supreme Court would therefore mandate the suspension order being issued. Concurrency of the same would extend for 3 months within the period. Memorandum of charge sheet is not served or delegate officer employed. The second part of the law mandates that if the memorandum of the charge sheet is served, the reason order must be passed. Lordship has come across. Reason order must be passed for extension of the suspension. Second part of the law declared by the Honorable Supreme Court cannot be read in isolation, has to be read in conjunction with the first part. Accordingly, it is understood that concurrency of the order of suspension, while not in being permissible to extend it beyond 3 months from the date of its issue, if memorandum charge sheet is not served upon the delegate officer. If memorandum charge is or charge sheet is so issued within a period of 3 months, the same must necessarily accompanied with a reason order. Reason order extending the order of suspension. In other words, either on the date of the memorandum of charges is so issued and invariably the date the same served the delinquent concerned. Such memorandum charges or charge sheet necessarily be accompanied with the reason order extending the suspension to the effect
This is an interpretation of what?
interpretation of the second part, my lord. Lordship on the law.
Judgments of the court don't require interpretation.
No, my
Judgments
lord,
of
it
the
is
court.
very much clear in the para.
Let us read the judgment.
Lordship, kindly have a look.
Let us read the judgment.
Yes, my lord. Para 21, my lord. I have page 303.
You are reading para 21.
My lord. We therefore direct the concurrency of the suspension order should not exceed beyond 3 months if within the period of memorandum charges or charge sheet is not served upon the delegate officer employed. If the memorandum charge or charge sheet is served, a reason order must be passed for the extension of the suspension.
That
reason order they have not given.
This is the order?
Yes, my lord. That is not the reason order.
Why?
Because, my lord, why the extension, my lord, has been given that page 77 does not indicate, my lord, that for particular reason the suspension is to be extended. That is the only my case. Because page 77 does not indicate, my lord, suspension, why, my lord, it is needed. And they simply said, my lord, page 77, my lord. 77, though I have served in the March, but it does not say so, my lord. During the period, in view of the above, pending trial of the departmental proceeding, suspension of the constitution is extended until further order. 2-line order.
Oh, before that, the paragraph?
Yes, before that also, Guwahati Municipal Board Corporation was intended to proceed further DP, which is already initiated against Khagen Chandra Das IC under suspension, considering the gravity of the charges, allegations against the Khagen Chandra Das Superintendent IC under suspension number so and so is undersigned, deem it necessary.
These are the reasons.
This cannot be the reason,
Why
man.
it cannot be? These are the
Judicial
reasons.
written, my lord, it without application of mind has been.
That is a different issue, but you can't say it is not a reasoned order.
That cannot.
You can say, you may argue that these reasons are not sufficient to
Not sufficient reason, my
extend,
lord.
but you can't say that these are not reasoned orders.
My lord, these are not the sufficient, my lord, my lord, without application of mind. And furthermore, my lord, I got retired also on 31st May 25.
24,
25,
25.
my lord. So only, my lord, since there is no
You were
temporary.
placed under suspension prior to retire.
Yes, yes.
And proceedings?
Proceeding, my lord, it is not has come to the conclusion.
When was the show cause notice issued?
So cause notice, I have had issued, my lord, I have replied
Prior to
also
your retirement.
prior to my return. On March, my lord, lordship will see page 38.
This will require some hearing. Require some hearing.
My lord, I got retired, my lord, everything got
You
halt.
may have retired. Now what can be done? The problem is that these rules nobody has challenged the rules.
My lord.
Unless the rules are challenged, there's no question of interpretation of the rules. Reading down, reading something more into the rules.
I had an impression
So-
because coordinate bench has passed the order,
The
my lord.
coordinate bench has passed the order, but
It has segregated the Ajay Chaudhary case in two parts. But again,
that
question will come,
require-
my lord,
that will require
whether
some-
this is a reason order or judicial
No.
application of mind was.
You are referring to the coordinate bench's order
My lord.
to show that this is how the order of the apex court is to be interpreted.
Yes.
Isn't it?
Yes, lord.
That's the whole purpose of para 29.
My lord.
That the apex court order at
Yes,
para
yes.
21 is in two parts.
Yes.
Part 1 is this, part 2 is
Two
this.
is this.
In the para 21, there is nowhere stated that this reasoned order for extension has to be given within 3 months after the issuance of your show cause notice. It's not there.
It is not
It
clear.
is not there in para 21.
Yes.
Not clear, it is not there.
Not there, my lord. Not
We
there.
can't read anything more which is not there.
Not there.
Now, whether it is possible for a court to interpret a particular paragraph to say that this is what it means, I will have to be convinced a little harder.
Lordship, then lordship fixed.
Require a little more convincing.
Lordship on the last occasion asked for Ajay to bring.
Therefore, I asked, because
Yes, yes,
subject to correction, I wanted to refresh my memory.
Lordship.
Say, para 21 only says 3 months extend or 3 months submit show cause notice.
With the reason.
Once show cause notice is submitted, reasoned order. It doesn't say 3 months or 6 months. But the state government has issued an OM where reasoned order is to be passed, even if show cause notice is issued, reasoned order to be passed, review of this order, review of extension of suspension is to be passed within 6 months. That is there in the state government notification. Now, whether this was passed within 6 months?
Yes.
Within 6 months?
Yes. Suspension was on 18/1, Lordship.
So the only question is that we'll have to examine whether.
Only, Lordship, at this stage, Lordship, as the person has already retired, Lordship, only relaxation, Lordship, he can be granted, is directing the authority to conclude the DP within a stipulated fixed period.
My lord,
Lordship.
that
is
way,
the
my lord,
only
they will
release
dismiss
they
me
can-
from service. At least my opportunity be.
That is the only option.
Whatever you do, but
and you may submit anything against the extension order, but that order is not under challenge. That extension order is not under challenge.
I did not get it because we got later.
we'll have to hear the matter.
Yes.
I have filed my affidavit, Lordship, with petition of.
Affidavit does not indicate anything, man. It is their mere factual matter, man. Flop and then never came in.
Don't expect me also.
But you don't dispute that para 21 does not say anything about 3 months.
My lord, I'll check it and I'll go
No,
further
you check it
scrutiny.
now. Why?
I'll go for further scrutiny line by line.
No, no, no. You go for scrutiny, we'll wait for you.
Lordship,
Para
I
21.
did not get, my lord.
Huh?
In para 21, I did.
You did not get.
I
We
did
also
not.
did not get.
I did.
Now, this is an order of the apex court. Can we put in words which is not there? What is not there is not there.
That is one, Lordship. Subsequently, Lordship, so far as that notification of 2020, that guideline was framed in terms of order passed by the court.
That was by a coordinate bench of this court.
So that also cannot be undermined.
So only question is whether the sufficiency of reasons.
Right.
And that sufficiency of reason, Lordship. If Lordship, Rule 6.1 is concerned, Lordship, pendency of a departmental proceeding is itself a ground. Statutory ground.
All right, third, Mr. J.I. Barboya, Learned Counsel for the petitioner. Mr. P. Nayak, additional lady appearing for the respondents. Pleadings are complete. Matter be listed for admission hearing. (23rd) October. On 23rd of October.
Right.
Supplementary list for admission item 64.
Yes.
Bad legal option. My lord, the petitioner's case for promotion has been kept under seal cover, though there is no criminal case pending, my lord. As per KV Jankiram.
Yes. Why seal cover?
My lord, I am yet to receive any instructions, my lord, in this matter. I have written a letter. We need further time to file our affidavit. But my lord, second thing is that the petitioner here in the writ petitioner stated that a vigilance case is pending and no charge sheet is filed. These are the things, my lord, on the date of consideration of the, my lord, promotion and everything. How do I know, my lord? Vigilance is not a party and we will not be, the department will not be privy, my lord, to those informations whether charge sheet is filed on such and such date.
Why kept under seal cover?
My lord?
Why did you put it under seal cover? Unless you are privy?
No, my lord. The thing is that, my lord, here, my lord, vigilance is need to be made a party, my lord, in this case.
You have put it under seal cover. You cannot put it under seal cover unless you are informed that charge sheet has been filed. Or some court has taken cognizance or something like that.
Exactly, my lord. That is why, my lord, I need
therefore, the authority department having put under seal cover.
My lord, that is why, my lord, here vigilance is not a party, so I don't have information and I haven't received the instructions from my department as of now. So that's why, my lord, I will need further time.
All right, that we'll consider, but whether vigilance is to be made a party or not will depend on what instructions come from your department.
My lord.
So when can you get instructions? Because you are getting buffer time of,
my lord, 10 days.
more than 2 weeks.
Lordship will certainly give time, but Lordship will kindly turn to page 46 of the writ petition. Lord, this kind of statement should not be, my lord, encouraged, my lord. They should read the file first. Page 46, this is a part of the recommendation of the DPC. Lordship will kindly turn to serial number 10, para 10. Departmental proceedings, vigilance case against officers. There is no departmental proceeding, criminal proceeding or vigilance case found, contemplated or outstanding against any of the officers in the zone of consideration, except Sri Vijay Kumar Singh, Prashant Brahma, Diganta Kalita, Biren Hendi Sundar, and Mohsin, that is the petitioner, Mohsin Ahmed. So they are aware, my lord, what kind of statement they are making, misleading this honorable court. So, my lord, next page, at serial number 15, I have my case is put under seal cover. Serial number 15. And all my batchmates have been promoted. Now this kind of, my lord, statements are being made to dilly-dally the matter. They are not aware. But this kind of statement should not be encouraged.
Is there any circular that vigilance case pending will entail seal cover procedure?
My lord, unless the instructions comes, my lord,
All right, get your instructions then.
my lord.
Mr. On the request made by Mr. Ard Hor, Leonard Standing Counsel for the department, that instructions are yet to be received. The matter is deferred. From the minutes of the selection board meeting held on 6/3/2025, which is enclosed to the writ petition, it is seen that the case of the petitioner has been put in seal cover. It is seen that the selection board recorded in its minutes that against the petitioner and some other officers, except for the petitioner and some other officers mentioned in the said minutes, there is no departmental proceedings / criminal proceedings or vigilance case found, contemplated or outstanding. Stop. Para counsel for the petitioner therefore submits that it is apparent that the case of the petitioner has been put in seal cover as the department was informed that a vigilance case has been contemplated or filed against the petitioner, which and as a consequence thereof, seal cover procedure was followed, which is contrary to the law laid down by the apex court in Janakiraman, KV Janakiraman, reported in so and subsequent judgments.
And their OM dated, my lord, 9 May 2006, page 61.
As well as the OM dated
9th
9
May
May
2006,
2006,
page 61 of the writ petition. Para 2.
issued by the Department of Personnel, within bracket capital B, Government of Assam. Stop. In that view of the matter stands deferred again to be listed on 29th October. The respondents are expected to complete their instructions as to whether on the date when the seal cover procedure was followed in respect of the writ petitioner, whether any charge sheet was a charge sheet or cognizance of any court of criminal court of competent jurisdiction was undertaken in respect of the writ petitioner. Well, list accordingly.
Deeply.
Item 65 and 56.
My lord, I am appearing in item 65, my lord. I have received the instruction, my lord. I need to file a response.
So in the item number 66, the Contempt matter, we send the affidavit for vetting, it is remain in Delhi head office. So for the 3 weeks time is required, my lord, as per the.
Yes.
My lord, kindly see the last orders in both the cases. So till the file matter is disposed of, my lord, we may not be thrown out from the present posting and.
Last order, only issuance of notice.
Notice, that's all.
No, interim, there is the interim.
Huh?
That interim prayer may be also considered. That notice was.
Interim prayer.
Yes.
What is your interim prayer?
Interim prayer in first item, my lord. I may not be reverted back to the post of head constable.
You are working as what?
I am working now as sub-inspector electrical in BSF. And as per rules, my lord, I am entitled for to be absorbed as sub-inspector, electrical. in
You're still
BSF.
working as sub-inspector, electrical.
My lord?
Yes.
You're still working, serving.
Yes, yes, I am still working.
Huh?
On deputation.
There are cases that they went in a deputation, malad,
Right.
pursuant an advertisement
Huh.
for the post of ZE, malad. Now, while they accepted the deputation, that is in my case, in 2023, they undertake a certificate. Or actually, we all things are by incorporating, we send it for vetting. It's remain in the office, Delhi office. There is a communication with Delhi that 3 weeks further time is required. This is the
No, that we'll
we'll
we'll grant you time, we'll grant you time. We are asking you,
My lord, kindly see the rules.
you are on deputation.
On deputation and
You have now
after
been recalled back to your parent department.
parent department.
Ah.
But actually, when I have completed ad head constable 10 years, and kindly see the rule. Rule says.
Where is the rule?
Yes, page 34 kindly see. In first item. 34 bottom, deputation, absorption. Kindly see 3. Serving border security force personnel in the rank of head constable, having 3 years diploma in electrical engineering from an institute recognized by the central or state governments, with 10 years regular service in the rank of head constable. So I am entitled. So 10 years, more than 10 years I have completed.
No, but.
And my post was also recommended by authority several times, madam. My higher authority, that those may be kindly seen page 25.
No, but you are on deputation, but have you applied for absorption?
Yes, yes, several times I have done, and my application was forwarded by.
What decision has been taken?
The
Page
decision
28.
20.
Decision, they say that there is a signal number so and so, that is 1425. Page 27 kindly see in the first item. But before that, I was recommended for promotion, for absorption. Now, my lord,
But your right of you are only required to be your deputation will. You see, deputation is only for a particular period. After that, you will have to be recalled or absorbed.
That is, the rule says that after 10 years completion of a head constable, he has the right to be absorbed as sub-inspector, electrical in BSF.
Where does it say?
Now, can you see my
Where does it say that you have a right to be absorbed?
Right means, my lord, the rule, there is a rule.
Rule says you are eligible for deputation.
Eligible. Now, my lord, so many persons have been already promoted, we have annexed the order also.
Now, promotion is different, deputation is different.
Absorbed. So many persons have been absorbed in, we have annexed the order in this writ petition that lordship may kindly see page 36. Judgment of our High Court also. And thereafter, they were all absorbed. So when we have become eligible, now kindly see for a moment, kindly see page 25. Page 25 of first item.
The judgment, I think one paragraph is missing. Page 38.
Even the SOP says, my lord.
There's some matter pending in the Supreme Court.
That I have no idea.
No, please look at page 39, 38, para 9.
The respondents have also contended that the number of deputationists have been repatriated to their original post as because the authorities came to learn that such deputationists acquired their diploma by means of distant education. No, we are not that. Some persons have obtained their diploma through distant mode of education, but we are from regularly recognized institution, there is no dispute matter. Now kindly see page 25. This
No,
is
no,
the-
read further in the same paragraph.
The agreed persons have approached various high courts in the country, and now all these cases have been transferred to the Delhi High Court and are under the supervision of the Supreme Court of India. The
Yeah.
supervision panel.
But they're all transferred to Delhi High Court
No,
by orders of the Supreme Court.
it is not said that those they are now transferred.
What is the
to-
status, Mr. Pegu and Mr. Goswami?
But my lord, in this case, the relief has been granted to the party.
So what is the order?
Order, my lord, that order may be
Get
seen.
the order.
Yes,
It
page
is possible
38,
that Delhi High Court may have already passed some order.
page 38, bottom can you see? I have considered the rival contentions and have perused the materials available on record. As per rules of 1999, the petitioners apparently could not so perhaps one page is missing. In the result, that even then can you see page 39 top. In the result, the respondent 4 and 5 are directed to place the names of the petitioner before the Board of Officers Screening Committee for their absorption promotion to the post of Sub-Inspector, Junior Engineer, Electrical within a period of 15 days from the date of receipt of a certificate of this order. The Board of Officers Selection Committee shall thereafter finalize their recommendation as expeditiously as possible and not later than 2 months from the date of receipt of the requisite proposal from the respondent number 4 and 5. Now, following this, my lord, now kindly see that page next. Here I have given all the thereafter. Kindly see page 51 of the next page, madam, of the next item. That's 51. Operative portion may be seen, my lord, page 52. A board of officer screening committee constituted separately for officers and ASOS ORS will be convened twice in a year in the months of January and July to assess the suitability of the deputationists and recommend their cases for absorption as per the eligibility criteria mentioned in the RRs and merits. The composition of the board shall be so and so. So in accordingly, my lord, these persons, kindly see now page 54, they have been, kindly see page 54, annexure 16. Consequent upon the having found fit by the departmental screening committee and as approved by the competent authority, following ASI RM who are presently on deputation to the post of junior engineer, sub-inspector electrical are hereby absorbed with immediate effect against the deputation post of junior engineer, sub-inspector electric sanctioned in BSF engineering setup in terms of the notified recruitment rules of 2012. As per 2012 rule, we are entitled, we are eligible. DO, POT guidelines and first data, so order number.
You file your affidavit, we'll hear.
My lord.
So, my lord, interim prayer may kindly.
No interim, no interim.
No, my lord,
Interim because you see, it is a question of, it's not a promotion, it's a deputation.
the deputation also.
If you are reverted back, if they have rejected your absorption, we'll examine that. But what interim do you
No,
want?
if
for
in the
deputation?
meantime we are sent back, my lord, for long years, actually earlier we are on combatant duty. And after this training, my lord, we have almost since last 5 years, we are not in.
Mr. Mahmood, learned counsel for the petitioner, Mr. B. Pegu, learned CGC for item number
65.
65. And Mr. Goswami for
Item number 65. Item number 66.
66. 66. Both the learned CGCs appearing in these matters submit that further time is required to file their counter affidavits. Stop. Meanwhile, Mr. Mahmood submits that they are still, the petitioners are still serving on deputation as sub-inspector electrical.
Yes.
And unless an interim protection is granted, they are likely to be reverted back to their post of head constable.
Head constable and sub-inspector GD.
Head constable / sub-inspector.
There are two cases.
Sub-inspector.
Sub-inspector in next item. First item is head constable GD.
65, sub-inspector.
No.
Head constable.
Head
constable, yes.
And 66 is sub-inspector.
Sub-inspector.
Sub-inspector. Stop.
BSF. Sub-inspector
BSF.
BSF.
Both are BSF.
Yes.
Both are BSF.
Yes, both are within BSF setup.
In the BSF. So, under such circumstances, this court considers it necessary to permit the learned CGC to file their counter affidavits within the next 3 weeks. Matter be listed again in the month of November on a date to be fixed by the registry. Meanwhile, until further orders, the petitioner's services as sub-inspector electrical shall not be
Because the
Yes,
SOP itself says, my lord.
till the next date, they shall not be reverted back to their original posts without leave of the court. You file your affidavit, we'll decide the matter. They are otherwise working as sub-inspector electrical.
And sub-inspector electrical, yes.
Then I'll list on a date to be fixed by registry. Fix it on 10th of November. 10 November.
My lord.
Obliged.
May I please, Lordship, further 4 weeks time required, Lordship, to file affidavit, instruction awaited.
My lord, there is a case, my lord, the petitioner was initially appointed on, my lord, 25/4/2024 as Ognivir. Then he, my lord, joined on 23/12/2024. Thereafter, my lord, he resigned on 5/1/2025. And after that, my lord, he has joined on 21/1/2025 as CRPF. But by order dated 8/8/2025, he has been, my lord, terminated without giving any notice.
We'll hear them. Mr. M.E. Mondal for the petitioner, MS.S. Borua, learner CGC for the state. MS. Borua prays for 4 weeks' time
Yes, Lordship.
to file counter affidavit. List again on 10th of November,
Yes.
Can it be earlier, my lord?
3rd November, 3rd,
Immediately after vacation, my lord.
immediately after vacation. Then we'll have it on 27th October.
Deep Lord.
27th October.
Public.
68.
Lordship, in this matter, Lordship, on the last occasion, Lordship directed me to obtain instruction as to the status of the proposal which was submitted, Lordship. Lordship, I have received an instruction from the Director of Medical Education, Lordship. Lordship, since the petitioner was reinstated on 16/3/2024, Lordship, thereafter the proposal was sent at the very fag end of the last financial year. So, Lordship, again, they have requested the principal of GMCH to submit the proposal of the petitioner, including other 3%, Lordship, at the earliest, Lordship.
So when are you proposing to submit?
Lordship, I have just telephonically informed Lordship. This has been received just now by me. So the principal has stated that he will place it within this week, Lordship. So, Lordship, let it come after, immediately after vacation, Lordship. I'll get the
It may be 6 minutes.
Yes.
Yes. Mr. D. Upamanyu submits that fresh proposal for Royal of Area salary is required to be submitted by the Director Medical Education.
By the principal, Lordship.
Huh?
By the principal GMC.
By the principal GMC in respect of the claims of the writ petitioner. The proposal Mr. Upamanyu, however, does not have an instruction as to the status of the submission of fresh proposal. He submits that the matter be listed in the month of October, by which time he will have these instructions. Accordingly, let this matter be listed again on 27 October 27.
Highly obliged.